Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Good morning, my couch potatoes. Good morning. I hope we're all excited to be here on this lovely Tuesday morning. It does not feel like Tuesday to me. Yesterday, I thought Tuesday. It was all Tuesday yesterday. It was not. It was Monday. Today, I feel like it's Wednesday because I'm like, oh, I got this to do. And no. That's what happens when I start planning out my weeks, is I remember plans for future days that are not the next day. Anyway, good morning, you guys. We are here for day 7 of the Brooks Houck and Joseph Lawson's trial. Almost wrapping it up. We'll wrap it up tomorrow. Today is only going to be about like 4.5 hours. And then tomorrow, you guys, is going to be a long day. A long day. You know why it's going to be a long day? Because they're total closing arguments. All right. Closing arguments is 6 hours. 6 hours for closing arguments for this case, which is just, I've never even seen 6-hour closing arguments before. I know during Karen Reed, they were given like an hour each, an hour and 15 minutes, maybe. I don't remember, but it was still, there was a time limit. And that was like a 8-week trial. And we were all like, that's not enough time. And that's true. This is a whole, 9-day trial, 8-day trial, and 6 hours in closing. Oh, so prepare yourself, folks. Tomorrow is going to be a long day. Today will be short and we're going to have fun. So anyway, let's say good morning to our chat. Good morning, 80s music man. Hope you're doing well. Oh, this mic, it just always wants to all over the place. Juju Bean, good morning. Hope you're doing well today, babes. Good morning. There's Mama Llama. Good morning, Mama Llama. It's nice seeing you briefly yesterday. Glad you got home safe. Dave, our good friend Dave. Welcome, Dave. Good morning to you. It is early on your side of the globe, but good morning. I love how early you are here. Am I dressed for winter? No, one, it's short sleeve, but also this is very sparkly. I said yesterday I was going to wear this for Simone because it's inspired by her dollhouse. So it's silver and sparkly. I also kind of feel like a spaceman, like in one of those, 70s sci-fi movies. Anyway, that's what I'm wearing today. Yes, there are 3 attorneys, but I can tell you Joseph's attorney doesn't talk a whole lot. No surprise to anyone. Brooks's attorney goes on for a while, and then prosecution does as well. So we'll see if I'll try listening to it after the show today and at a higher speed and see if that helps. I have a really hard time if it's sped up, understanding what's being said and happening. Like my brain, it's just like, it's too slow. It can't retain anything about that, especially when it's complicated things like that. So yeah. Juju says, wrap it up. Brooks went down. I've been listening to all his current prison calls. Ooh, interesting. I haven't heard those. Let me check those out. Good morning, Angie. Good morning. Hope you're doing well. Hope you're doing well this morning. Yeah. Ooh, so I'm also trying something new today. It's not, does not have as much caffeine as a Red Bull. Don't let it fool you. Has 80 milligrams of caffeine. But I'm trying these new V8 energy drinks for the morning. Excuse me. Orange pineapple. Sounds good. And it has like 80 milligrams of caffeine, which is similar to a cup of coffee. Well, it's about 60 milligrams less than a cup of coffee. But, it contains my fruits and veggies that I need or something. So we're going to try it out and see what happens. I have 2 different kinds. I have orange pineapple, and I don't know what the other kind is. I don't know. Wolfie picked them up for me. I was like, okay, we'll try. We'll see what happens. Yes, guys, if you haven't yet, please do hit the like button because then I earn a gavel. And it lets everybody else know that we're live and that today is where the party is going to be. So hold on just a second. No, that's just a reminder of something not important. V8 is too healthy for you. I love V8. I love the regular kind of V8. I love the fruit smoothies. I love the splash. I'm a big fan, but apparently they were having a very good sell on these. So V8 was like, how about these? And I'm like, fine, whatever. I don't know. You've been at the grocery store too long and on the phone with me. So whatever. Just pick up whatever. But anywho, kiddos. So yeah, tomorrow we'll have a long day. Today's going to be a short day. Thursday, don't forget, 8 p.m. Eastern. Our podcast, True Crime and Wine Time, will be covering part 2 of the John List nightmare, because that guy is the worst. There will be more rants. I can promise you that. So we'll be doing that 8. The lovely lady in gray right here is going to be my co-host again to finish that story off with me. So that's what we'll be doing this week. You can't drink V8s. It's the texture. That's fair. The splash is just juice, though. It's not like thick. The smoothie is kind of like that. This one, I don't know. Actually, here, let me just open it because I haven't even tried it yet. So we'll see. Oh, I didn't see if it said shake well. Oh, well. Oh, no, this is just like juice. Not thick like, V8. So you might like this. I don't know. It just tastes like orange and pineapple juice. Okay. I'm so ready to be done with John List. He's terrible. I hate that guy. Anyway, let's bring up court today, besties. Okay. There we go. There's our favorite judge, Judge Sims. Do you swear? I'm gonna miss him. Yeah, they're pretty good. It's literally just, well, it says 50% juice on it, so I don't want to say it's 100% juice, 50% juice, but it's still good. Okay, let's see what we have in store today. I think they only have like 2 witnesses on the stand, according to my notes here. Yeah, Jeffrey Nowschatz. Oh, I don't know how to say that last name. He's a cognitive psychologist. And then Denver Butler, who's a retired Louisville Metro Police Department sergeant. So I don't know what they're going to have to say. I'm sure the cognitive psychologist, I bet they're there to talk about coercive interviews and interrogations by the police. I wonder. I don't know that for sure, but his accent, I love it. It's adorable. My Southern friends are very self-conscious about their Southern accents because people think they're dumb, and I don't think so. They're not dumb. I can tell you that. I talk to them all the time, but I think it's adorable. I love accents of all kinds. Because, it'd be boring if we all had my boring Ohio accent. So I love it. So anyway, all right, let's get going. Shall we, kids? Okay. Oh, we need, let's see, closed caption. Come on, Mama. It's not your first day. I wonder how earbuds, guys.
The record reflects all 15 jurors have returned to the courtroom. Everyone may be seated. Counsel waived the call.
Yes.
Greg, call your next witness.
Yes. Jeff, new shots, please.
New shots. I was kind of close, but not really. All right. New shots. Not how they spell it.
Jeff, new shots. He should be in the new shots.
Jeff, new shots.
I'll stand here.
New shots. Oh, I guess it kind of makes sense when you look at it. What is he again? Oh, yeah.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You have a seat right over there. Try to sit as close to the microphone as you can, and please answer all questions asked of you.
Thank you.
Mr. Butler, proceed when you're ready.
Thank you, Your Honor. Could you introduce yourself to ladies and gentlemen of the jury, please?
Jeffrey Neuschatz. Is that okay?
Yeah.
Jeffrey
There you
Neuschatz.
Thank you, sir.
Neuschatz.
go. And can you tell us what you do for a living, sir?
I'm a core faculty member at Fielding Graduate University.
And what specialty are you?
I'm a cognitive psychologist.
And sir, can you tell us a little bit about your educational background to become a cognitive psychologist and then what a cognitive psychologist is?
So my educational background, I got my bachelor's degree from Roger Williams College, which is now Roger Williams University in Bristol, Rhode Island. I then got my master's degree in general experimental psychology at Cortland College, which is part of the State University of New York system or SUNY system. And then I got my PhD at Binghamton University in cognitive psychology, which is also part of the SUNY system. Cognitive psychology is the study of any brain processes, thinking, judgment and decision-making, language, problem solving, memory. My particular expertise is in memory, and I've applied that to issues related to psychic law.
And sir, can you tell us, you said
I'm not
your
here
current
for
position,
course.
where did you
Okay.
work before that when we first met?
I used to work at the University of Alabama in Huntsville, which is not the one with the football team. It's one of the sister schools.
And now, so tell us when you got your PhD, kind of walk us through your work history with cancer.
So I worked 1 year as a visiting professor at St. Mary's College of Maryland. And then I went to the University of Alabama at Huntsville for 25 years. And in January, I took a position at Fielding Graduate University.
And what types of courses have you taught, sir?
I'm an experimental psychologist, so I've taught almost all the experimental classes. So introductory psychology, learning, cognition, psych and law, interrogating and investigating, wrongful convictions, research methods, all of them, basically all of them in the experimental realm.
Interesting.
Have you done research regarding confessions?
I have.
Okay, can you,
So they
not
might be
keeping us
coming
here
in.
all day, can you give us some idea of the type of research you've done regarding?
So my research regarding confessions has been very much on cooperating witnesses and jailhouse informants, so how they're perceived by juries. I've also looked at how I call those confessions secondary confessions because they're saying that somebody else did. And I've compared those in some of my work to primary confessions, which is when I'm confessing to crimes I commit to see how they are, perceived by jurors when they hear them. in
Oh,
situations like
interesting.
this.
You mentioned one of the things that you are proficient in is eyewitness memory.
Yes.
And can you talk about what type of research you've done in that field?
So I've been doing eyewitness research probably for 30 years. I've written a book called The Psychology of Eyewitness Identification. We're currently, I think we've completed or we're very
Seems
close to
interesting.
completing the second edition of that book. My research has been concerned with two factors. One of them is the confidence of the eyewitness, and the other one is what's called post-identification feedback. So after you make an identification, right, I picked that guy or that girl, what information you get afterwards. So if someone says you picked the right person, or sorry, that wasn't it, how does that person then think about their experience of identifying the person, and then how do they relate that to a jury, and what does the jury think of them?
Aside from the book
I
that
learned
you're
some
writing,
stuff
you've
today.
been published in papers, sir.
I have.
And can you give the jury an approximation of how many
Also, why is the
papers
font
you've
outright?
published regarding either cooperative or what you call incentivized witnesses, meaning they're getting something for what they're saying, or eyewitness memory type situations?
So overall, all my papers are just my peer-reviewed papers.
Why don't you say overall the peer, then tell us how much the peer review?
I think overall I've published close to 75 papers. That includes books, chapters, and articles. And I think articles I've published close to 55. I think most of those
I don't know how to fix that.
are regarding eyewitness identification, line of identification, and about 20, I would say maybe
Sorry. I was trying to make the font like more bright white, but I don't know how to do that. So
18
it's fine.
are on jailhouse informants, cooperating witnesses, and I've written a book on jailhouse informants, cooperating witnesses.
And have you testified as an expert in state court regarding, or state and federal
No.
court regarding
The risk assessment for
In state
parole
court,
and
not in
probation,
federal
I
court.
think is
And what
actually
about
the
with regard
problem.
to eyewitness testimony or memory issues?
In eyewitness, I've testified
In numerous
state,
scenarios,
federal,
they're not
and
wrong.
military court.
Now, in this case, you were asked to review a multitude of interviews, correct?
Yes, sir.
Some of which have become relevant, some of which have not.
Right.
Would you estimate how many hours you've gotten into this case?
I would say close to 60.
And thus far, how much have you been paid?
$10,000.
All right, so the going rate is
Now-
$10,000. Okay. I need to become an expert on something.
Did you also, in your experience, train law enforcement?
I gave a training on interrogations and interviewing for the Huntsville Police Department last summer.
Judge, I moved to the admission of him as an expert in cognitive psychology regarding interview techniques as well as memory.
Any objection?
No, sir, I'm sorry.
So stipulated.
All right, let's start with memory, sir. Can you kind of give the jury a broad overview of how memory works, please?
So memory doesn't work like most people think it does, right? Memory doesn't work like a VCR. You don't have a picture in your brain. What happens when you witness a complex event, like a basketball game or a wedding, you take in bits and pieces of that event. And those pieces that you take in aren't organized. They don't have a lot of detail, right? So as the rememberer, you have to fill in the gaps with the details and the organizations. And you do that based on what you know happens in the world. Sometimes the information you add in is accurate, sometimes it's not. Now, once you have a memory, it's not written in stone. It changes all the time, right? When you collect other information, what we call post-event information after the event, that has the ability to change your memory. And that can happen unbeknownst to the person trying to remember the information. So that's why we can have confidently held, richly detailed memories that may not be completely accurate as they happen. That's not to say all of our memories are wrong, because we know that's not true. When we go home today, you'll all go to the right house, put the right key in the door, and walk in, right? So those things that we practice over and over and over again are likely to be accurate. It's those things that we see for shorter periods of time that we don't do all the time are the ones that are more susceptible to these types of changes that we're talking about.
Now, you talked a little bit, and I want to talk a little bit more about a psychological term, post-event suggestion. You mentioned a basketball game. Let's just use that as an example of how a post-event suggestion may impact your memory of a basketball game you watched.
So the way post-event information is probably one of the most studied things in memory. And what happens is that when somebody tells you something after the event, right, you might incorporate that into your memory. So if they said, number 32 hit the basket post number 15, you may think to yourself, maybe it was 32, and replace your memory with 32 hitting the basket as opposed to 15, and then tell other people, well, this is what happened. It's especially true if the information is coming from a credible source or an authority. You're more likely to accept that information.
True.
So within this field, who was the foremost authority, and where did some of this research get started?
So the foremost authority is Beth Loftus, Loftus, and she started looking at post-event information. And her seminal study was about a car crash. So people watch a car crash, and they're simply asked afterwards, how fast were the cars going? And she just changes the verb. Bumped, smashed, collided. How fast are the cars going? So if you hear bumped, right, this is a filling the gaps. You might say they're going 15 miles an hour, because when cars bump each other, they're usually not going too fast. If you heard smashed, you might say 30 miles an hour, because when cars smash into each other, they are going faster. And then what's really interesting is she was able to change the speed estimates by the verb, but a week later she asked them, was there broken glass at the car scene? And the answer is no. But if you heard smashed, you were more likely to say that there was broken glass, even if there wasn't. And the reason being, as we talked about, memory is constructive, so you fill in the gaps with what's most likely going to happen based on what we know about the world. And when cars smash into each other, there's generally broken glass there.
Which makes sense.
How can media coverage potentially impact what you call post-event, or the literature calls post-event suggestion?
So this is information in the media that you're getting after the event. For some of you, maybe before the event, but it has the ability, like the verb, to change your memory based on what you're hearing, especially considering a lot of people see the news, or at one time they did, as a very trusted and credible source.
How does the exposure to an event, time-wise, how does that potentially impact memory?
So if you think back to if you're asking me about exposure time,
Yes.
when you think back to when you were studying for exams, the longer time you spent with a material, the better you were able to retain it and hopefully do well. So the longer you have to see the information, when it's not occluded, when you're not stressed out, when you pay full attention to it, the better your memories are going to be, meaning they'll be less susceptible to this post-event suggestion.
How can elements such as whether it was light or dark out when you say you saw something, how might that impact your memory?
So anything that makes it easier to see, right? More visual acuity, you're able to make out more features, which gives you more cues to memory and easier to get things out. When it's dark out, you can make out fewer features. So it's harder to encode, get into memory. There's many features, so you have less avenues to get it out of memory, and it's harder to get that information into memory.
I wonder
So
what
it
it's
harms
like
you when it's dark out two ways.
for people
You don't
like me
see
to
as
have
many features, so there are
aphantasia.
less things in memory.
Have they
and
studied
you have fewer cues
eyewitnesses
to
with
retrieve
that
those
before?
things to get them out accurately.
What about distractions, such as if I said I saw something while I was driving, or I was texting, or I was calling someone, or any myriad of other things I'm doing at the same time?
Same as when it was dark out. Anything that doesn't allow you to see the information fully, makes it harder to get a full exposure to the information, makes it more difficult to have strong memory traces. And when the traces are weaker, they're more susceptible to post-event information.
And what about time after the event?
So retention interval is the amount of time between when you study and when you test it. So if you study today and you're not tested till next Thursday, that's a week retention interval. The longer the retention interval, the harder it is to remember things accurately if you can't rehearse them.
Now, can you tell us a little bit about a study you did? I think that maybe illustrates some of the points you're making back in 2001 involving asking students to walk into an office. Can you explain that to me?
So what we did in this study is we were interested in,
No shit.
people coming up with false memories.
Good.
Memories for events that didn't occur.
I saw that surveillance
So what we
video
did is
come
we
on
asked
thing. I
students
was
to
just
come
like,
down
"Oof,
to participate in the study, and we asked them to sit in an office.
good.
And we didn't tell them, some of them we did, some of them we didn't tell them that the study was actually remembering what was in the office. After a minute or two of sitting in there, we take them out of the office and we ask them to remember information that was in the office. And what we did was we left out a lot of stuff that's typically in an office. Notebook, stapler, pencil, copying paper, all that stuff. And we gave them a recognition test and asked them, did they remember seeing these things? And there were 10 items. And what we found is that people could remember those items that weren't in there. About 40%, 45% of the people, 45% of the items were actually remembered, even though they were never in the office. This goes along with what I told you about filling in the gaps. You fill in the gaps with what's reasonable and what you know about the world in the situation. And we know when we go into an office, usually there are pens and there's papers and there's books. When those things aren't in there and you don't have a great memory of it, you think to yourself, yeah, it must have been in there, right? Because that's what's typically in an office. Why wouldn't it be in there?
Can you witness an event and have a posted suggestion to change what your memory of that event was?
Yes.
Sure.
talk about one of the classics in your
He's the
field.
one that left the baby on that front
Everyone
lawn and then like
remembers
had
9/11.
killed her whole family or
Everyone
something.
remembers
But the Montana
George
guy
W.
is
Bush was the
still.
president at the time, and he was in a classroom in Sarasota, Florida, talking to little kids. And Andy Card comes in and whispers to President Bush. We don't know exactly what he whispered, but something, the country's under attack or something to that effect. You recall that?
Yes.
And can you tell, ladies and gentlemen of the jury, a little bit about the psychological impact of what happens after that with President Bush?
So it's written about a lot about President Bush and it's not a comment on President Bush. Well, maybe some people are, but it's really a comment on how memory works. He was reading to students. I think it was called The Pet Goat, or he was reading with the students. He's told about this in another classroom. He gives a briefing. Later on, when he's asked about how he found out, he says that he's seen news footage of the planes crashing into the World Trade Center. Of course, that's impossible because by the time he was told about it, there was no footage out of that happening, right? He's just making a memory error. Did he in fact see planes? I'm sure he did, right? But his memory is, how do I usually find out about these things? Is on television, so that's how I must have found out, opposed to how it actually happened. And that's the way memory works, right? It's constructive in nature. It's not like a VCR. And when we have information or we know things about the world, we update our memories, whether that information is accurate or inaccurate. I'm sure if you asked George W. Bush about it, he would be very confident that that's exactly what happened, even though we have documented evidence that it's not what happened.
No,
I did not know that.
There's no old-fashioned lineup in this case where the police bring in people and line them up and pick out the right person. But you're familiar with that stuff, correct?
Yes.
And sometimes police, this is not part of this case, but sometimes police will show what they call a photo pack, where they show several pictures to someone that might be a witness to an event, and they'll ask them if they see the person in there.
Yeah.
Okay. You're familiar with those kind of things.
I am.
Good morning, Teresa.
Can you explain to the ladies and gentlemen of the jury
Good morning,
with
babe.
memory, and it's one of the things I think you said you studied extensively. If I say, golly gee, I'm certain that Barry is the person that I saw in the courtroom in Louisville last month, and I'm 100% certain, Professor. Explain that certainty, and is there any correlation to that with being right?
So it's called the confidence accuracy correlation. Is there a correlation with confidence and accuracy? It depends how the test is given. If the test is given immediately and it's given as a fair test, meaning there's no bias, then there is a correlation between confidence and accuracy. So people who are confident are likely to be accurate. However, if it's not a fair test, it's a biased lineup. If it occurs way after you make the identification or the memory, then there's no correlation between confidence and accuracy. One of the things I studied, I told you I studied confidence in eyewitness, and what I studied was how confidence at trial affects people's judgments of the witness, even though it wasn't related to their accuracy.
I mean, that's how I feel about
Now-
the defense for Joseph. I was like, he needs some confidence because he doesn't seem
We
like
heard
he has
testimony
anything,
from
which is obviously
one of
not
the
true.
police detectives in the case. I wish Detective Snow here at the end, that he, in the early part of this investigation, received a multitude of tips. People seeing a car here, people not seeing a car here, people seeing this, not seeing that. Why does that phenomenon happen? Obviously, not everyone's calling in to lie and mislead Detective Snow.
I mean, a variety of reasons. So that we see in the confession and eyewitness literature is that some people want to be involved in the case. I may be aging myself, but if you guys remember the Joe Benet Ramsey abduction, several people came forward and said they did it just because they wanted to be the notoriety of it. So people say that thing. Other people like that, I'm sure they actually believe that they saw something that was relevant to the case, and they may have in fact seen something that was similar to what they were talking, and they wanted to do their civic duty. It just may not have been relevant to this particular case. Other people just want to be in the media because they want the fame associated with it.
Now, if you see something, kind of wrapping up some of this, but if you see something very quickly, and then later, a day or two, you see things on the media, you hear things, can that impact what you think you saw?
Yeah, it's post-event information, and it has the ability to change and contaminate your memory.
I had 1 second, Your Honor.
Fascinating. I find the brain to be the most fascinating thing in existence. That in the universe. But really, the brain is.
Now, Professor, you also, in
I love
the
it.
course of this, looked at interviews, and we'll get to those, correct?
Okay.
Can you tell, ladies and gentlemen of the jury, what the Reed technique is?
Oh
The
boy.
Reed technique is an interrogation and interviewing training technique.
It is not
It's
good.
probably the most popular one in the world. They've trained tens of thousands of people. I myself have taken the training. That thing I started in the 1960s. They have a 9-step process for how to interrogate people and get them
Yes.
to get
Why
them to
eyewitness
confess.
testimony is usually
Although they say
rated
the goal
very
of their
low.
procedure is just to get facts of the case, not to get people to confess.
And then when
the
you
Reed
have
technique,
non-credible things about
we're not going
them,
to get into all the
even lower.
criticisms of it, but the Reed technique has been criticized by people in your field, correct?
It has.
But it's typically still used by a lot of law enforcement agencies.
Yes, and when I took the training, it was me and almost entirely police officers and people who worked in store security, theft prevention.
And in this particular case, are you familiar with whether Detective Brian Luckett took the training?
I am.
And he took the training in August of 2022, correct?
I believe that's correct.
You're still teaching this in 2022?
Now- Is it fair to say that the Reed technique is maybe the most coercive of accepted practices by law enforcement for interrogation?
That is how it is talked about in the social psychological literature.
Now, but there's certain things, even though it is considered the most pushing the line, I'm going to call it, in interrogation techniques, there's certain things that the Reed technique that's taught to law enforcement across the country tells you not to do. Is that accurate, sir?
That is true.
Okay. What does the Reed technique that all police are trained on, or interrogators are trained on, tell you to do with regard to what I'm going to call promises of leniency? And if you could explain to ladies and gentlemen of the jury what a promise of leniency is.
So a promise of leniency is offering somebody something, reduced sentence, some benefit in order to confess. It's one of the things that they are very adamant about, that it's coercive to do that. That they say you should absolutely not make promises of leniency to people to get them to make statements.
Especially
Why?
because they can't even really
Because
do
it's
that.
coercive. And the reason the Reed technique has said any of these things, if you read their documents, shouldn't be done is because other courts, if I'm allowed to say, have found these things to cause involuntary statements.
What's the Reed technique say about what I'm going to call inevitable consequences? And if you can explain what they mean by that.
So threats of inevitable consequence, they said you shouldn't do that. Once again, it's one of those things that they find overly coercive and that you should not do. So you shouldn't say to someone, if you don't confess to me right now, they're going to lock you away and throw away the key. You shouldn't make those sort of threats to people when you're doing an interrogation to get them to make statements.
What about if the threat's not to directly to them and what's going to happen to me, but it's a threat to take my children, for example?
Mm.
Yes, they also say that that is also coercive and you shouldn't do that in order to get someone to make a statement.
No, they already did that.
What do they
bunch of that
say
we've heard.
about lengthy periods of
So what they say is, and this is based on the research, is one of the biggest risks for false confession or false statements is the amount of time that the interrogation lasts. So their argument is that interrogation should not last over 2 to 4 hours. And the reason being is that people become fatigued And when they become fatigued, they no longer have the cognitive resources to make voluntary statements sometimes or to fend off some of these tactics that we're talking about.
What about what I'm going to call contaminating? We talked about contamination of your memory by post-event suggestion. Let's talk a little bit about contamination of your statement. What do they say about investigators feeding facts or suggesting what you're supposed to say?
So what they say is that you shouldn't give all the information to the witness. And the reason that you shouldn't do that, or the suspect, is because one way to assess if an interrogation is accurate is if the person has guilty knowledge. So that if I, as a suspect, know information that only the person who committed the crime had, you want me to say that myself. If it's leaked into the interrogation by an investigator or by showing the person evidence, it's no longer guilty knowledge, because you don't know if it came from the person who's confessing or if it was given to them by the police officer. So it doesn't allow you to check the accuracy of the confession anymore.
Mhm.
So, for example, if it was a crime to be in this courtroom and you were interrogating me about it, and you suggested to me that Judge Sims's nameplate's not there on the bench, and then I came along and said, well, Judge Sims's nameplate's not on the bench. Can you explain how that?
Can I use a different example?
Sure.
Let's say I come in and I show you pictures of the victim who was shot 2 times in the shoulder and 1 time in the knee. And then in your confession, you write, yeah, this person was shot 3 times, 2 times in the shoulder, once in the knee. I no longer know if that came from me or it came from the pictures that were shown to me during the interrogation.
Mm-hmm.
So that if I just said that without seeing the pictures, you would know that I was the person who committed the crime. But by showing me the picture, you no longer know if that was coming from me or if I just intuited that based on what I was shown in the evidence. Does that help?
Exactly.
Yes, it's much better than my example. All
You're
right.
gonna be started on
So
Freud and his cocaine letters to a doctor. They're hilarious.
part of
if
what
you've never
Reed
read
has
them.
published about things not to do, we touched on
Freud.
some of them, based upon wrongful convictions using this technique, correct?
You can find them
Yes.
online.
And what has Reed's position been on the wrongful convictions per coercive interview tactics?
Reed's position is that the only time you get false statements and false confessions is when you don't follow the Reed tactics or the Reed 9-step process as they want you to do it. So if you do these things that they forbid you for doing, they think those lead to involuntary statements and false confessions. So as long as you follow their procedures, they say you'll get faithful results. But if you don't, that's when you'll have these coerced statements.
And is it fair to say, based upon your research and your training experience, the 2 areas that have led to the most wrongful convictions are coercive interviews and eyewitness memory problems?
Yes.
It depends which group you look at. So if you look at the National Registry of Exonerations, which counts all exonerations, right, they say the biggest 2 factors for wrongful conviction are perjured testimony and false accusations and official misconduct. So 64% of cases had these false accusations or perjured statements, and 60% had official misconduct. If you look at the National Registry of Exonerations, they say the biggest factor, if you look at the Innocence Project, for them, they're looking at saying eyewitness identification is the major factor, or one of the major factors in wrongful conviction. And they're just looking at sexual assault cases that have DNA exonerations. That's the difference between the 2.
So both are prevalent in the literature for wrongful convictions.
Yes.
Now, what is the goal of an interview?
According to Reed and most interrogation trainings, it is only to collect facts of the case. It is not to get it's not to get a confession or a statement.
Is the goal, according to Reed or any other interrogation tactic, taught to force fit someone to say what you need for your case?
It is not.
Now, I want to talk about 2 particular people that were interviewed that have become relevant to this case. Did you review Kentucky State Police interviews with Charles Kirkland?
I did.
And did you review Kentucky State Police interviews with Heather Snell.
I did.
In particular with Ms. Snell, I'm referring to a September 2023 interview. You're familiar with that, correct?
Yes, I am.
Okay. Let's start with Mr. Girdley. How long was his first interview?
That guy.
In June of 2023.
So it's a little bit unclear because with interrogations, we code them from when they're detained, not when they start being interviewed. For the best of my knowledge, during the interrogation, they said that they wanted to interview him at 4 o'clock. The interview doesn't start until 10 o'clock and it doesn't end until about 2. So the most conservative estimate is 10 hours that he was detained and then interviewed.
And the actual interview itself was, I believe, a little over 4 hours, correct?
Yes.
And you talked a little bit about this, but what effect does that time have on the interview's course?
So we mentioned that one of the leading causes of wrongful confessions, false confessions, is length of the interview because the person becomes worn down and no longer has the cognitive resources to answer questions. So that it's one of the biggest risk factors for false confession.
And one of the things you do is you code an interview. Can you explain what that is, ladies and gentlemen of the jury?
So we have a coding measurement. It's been psychologically tested and validated, and it allows us to look at several things or tactics that are used in an interrogation. So the first thing we look at is what are called personal risk factors, and that involves the person, right? So that we look at their age, right? Because youth are much more likely to false confess. We look at if they're in pain, because when you're in pain, you have trouble like with all your cognitive abilities. If they're drunk, if they have any intellectual problems, if they have any psychological, if they're on any medicine, because all those things make it harder to answer the questions and fend off any tactics you have. So first thing we look at is their personality, their personal risk factors. Then we look at situational risk factors, which include 5 categories, I believe. One is which is called rapport building, which is small talk between people. We looked at evidence tactics, which is when people either make up evidence or say they're going to have evidence that doesn't exist. We look at what we call maximization or consequential tactics, is when people when the investigator tries to leverage the full weight of the law against not confession, right? So when they say things like, we're 100% certain you did this and you're going to go to jail, right? So they say those sort of things. Then we look at what we call social psychological factors, which are things that are supposed to increase the person's guilt, not their guilt in the crime, but their own personal feelings of guilt. Comments like, don't you think your family would feel better if you just owned up to it? Why don't you stand up and be a man and admit what you did? The victim will be able to feel better and move on if you just admit it, those sort of things. And finally, we look at minimizations. Minimizations are things where they try and lessen the severity of the offense and or the consequences. It's not so bad. Everyone goes out and get drunk occasionally and they drive their car, so let's just get with it and we'll get it handled. Things like that. So making it seem not so bad. And then the last thing we look at is contamination. So who says what information first? So we look at what information is in the interview and who says it, whether it's the investigator or the person being interrogated or interviewed.
And can you give us a rough estimate of how many of these tactics were used on Mr. Girdley in this first interview?
In the first interview, I know across the 2. In the first interview, can I check my notes?
Yes, sir.
I must say, this guy is very fascinating.
I have 314.
314.
We'll get to some of the specifics and how you got there, but do you have an opinion based upon your training experience? Was the interviews with Mr. Girdley coercive?
Yes, it's very coercive.
Now, Ms. Stellan, I think her interview was in September think we've seen bits and pieces or heard bits and pieces, a little over 4 hours, 4.5 hours.
Yes,
And likewise, did it contain coercive tactics?
it did.
Did it contain a multitude of coercive tactics?
It did.
In your opinion, was this a coercive interview?
I think that we counted in that one around 350 coercive tactics, a lot of promises of leniency and implied threats that she would not be able to continue to take care of her child if she did not come across with the information they were looking for. So to answer your question, yes.
I'd like to start
Wow.
with Mr. Girdley's interview, if we can. What type of impact might it have on the coercive nature to be under arrest and have threat of prison or revocation of probation on the potential coerciveness of the interview?
A lot.
So that a lot of times when people are interrogated, they're looking at some prison time. The situation itself doesn't automatically make it coercive in that regard, unless it's being offered as a nugget to get out of those things.
What about touching people?
So it's very odd, right? So that if you watch Girdley's interviews, and I was struck by this, so we counted, he's touched his knee, his shoulder, his arm over 50 times during the interrogation. And the way in which we coded that is very unusual, and it's not talked about in the Reed technique as something you should. I mean, you shouldn't punch people, you shouldn't threaten them, you shouldn't get aggressive. But these are more like affectionate touches. And we coded those
Hello,
things
Michael.
after we decoded. We decided that
Yes,
they were
we're wrapping this one up
shows of
tomorrow.
affection
Yes.
during the thing, like trying to make the person feel more relaxed, or a show of sympathy, which are things you shouldn't do as an investigator, because it makes the person trust you more and may open them up to talk more than they ordinarily would.
Well, what's wrong with that?
Well, you don't want to mislead them in your role, right? And one of the things we're talking about in rapport building is that it's okay to ask people questions. You got to start the interrogation some way. It becomes problematic when you misrepresent your role as a police officer. Your role is not there to befriend somebody. It's not there to help somebody. Your role is simply to collect the facts of the crime.
So what's wrong with saying, well, I'm your best friend?
It's extremely coercive because that's not your job or your role there.
And that's why it's hard to, even if these witnesses were
What
telling the
about saying
truth,
things like,
doesn't
I
matter.
don't care what you did, you're not going to jail today?
So those are what's known as minimizations. We talk about minimizations when you say that the severity of the crime or the consequences are going to be less. So when you're telling someone you're not going to jail, it's a minimization. So you're trying to tell them this in order to get them to give the story that you want them to give.
What about saying things like, this is the most pivotal moment in your life. You can take this fork on the road and do what we want, or you
Same.
can take this fork in the road and you can spend the rest of your life in prison.
Depends on how it's said, right? So the first part is that this is the most pivotal moment is telling the person what we call self-interest. It's in your self-interest to tell us what we want to know. If they go as far as saying, if you go into jail, that's a threat of inevitable
Oh, we watched the
consequences.
Lori Vallow trials.
If they don't go that far, just say this is the most pivotal moment of your life.
I wasn't sure, so I didn't want
It's
to
just
say
a
it. That's
tactic
exactly
related
what I
to
thought. About.
Self-interest. So it's in your self-interest, and there's an implied threat there that if you don't do this, there are consequences that are going to happen.
Always have a lawyer.
And if we can go ahead and cue up clip GA, please. Yeah, Judge, should we have the headsets for the jury at this point?
You have headsets? They don't have headsets.
I'm sorry.
They're saying they don't have headsets.
Oh, you don't have headsets? Okay, go ahead and play. It's fine. I can hear good.
Let me tell you, you cannot be a witness for us in any single way. Okay, we lose you if we don't have that credibility.
Okay, so this is the very beginning of the interview. Is that correct, Professor?
Yes. Yes.
And that's, I think we have it bookmarked at about three minutes or so into the interview. So the investigator's saying we lose you if you have any witness credibility. What I want to like to do for the ladies and gentlemen of the jury is kind of walk through how certain statements were made. So one of the first statements that Mr. Girdley makes to the police is that Brooks Houck asked him to move Crystal Rogers' car. Okay, and you're aware that he ultimately provides that information to the police.
Yes.
Okay. So this is one of the first things they say. If you could play clip G13 for us at the beginning of the interview.
On your part, we can do a lot to help you, okay, and we can do a lot for you. And usually you don't have a prosecutor assigned by the Attorney General's office on hand to make any kind of negotiations. Tonight you do.
Okay, let's kind of break that down. So one of the first things he says is we can do a lot to help you. How does that, based upon the research and the read technique, is there any issues with that?
It's a promise of leniency.
What about how does it potentially affect the coercive nature of it to say we have a prosecutor on hand and he's actually appointed by the Attorney General of the state?
What that is called is emphasizing the seriousness. And what it means is once you emphasize the seriousness, obviously the Attorney General that was appointed by the state wouldn't come down on any old case, right? He's coming down on a pardon case. And what that says to the person being interrogated, not only is it a serious case, but when the cases are more serious, so are the consequences.
You could play clip GH for us, please.
And, you know, when I bring somebody in this room, I'll be quite honest with you, I already know what I'm looking for. You're not the person we're after, okay?
Okay, is there any issue with telling someone, I already know what I'm looking for?
We call that an evidence tactic. So what you're saying to the person is, I already know all of the evidence, so any stories that deviate from what I already know are going to be rejected.
And what about saying, I'm not after you?
So it's a minimization again. So you're reducing and the severity of what's going to happen to the person if they give you the information that you want.
You could play clip G3.
This is important to us. I'm very passionate about this.
So he's saying it's important, we're very passionate about this. How might that impact the interview?
Once again, it's emphasizing the seriousness of it, and when things are very serious in legal situations, the consequences are greater.
If you could play clip G3A, please.
We want you on our team.
If you could play before we ask the next.
I
Play the
mean,
next clip. That's it. About 9-10
nobody's
minutes
great
into
in
it.
this
If you could
story.
play the clip shortly thereafter, 10:36 G14.
It's all frustrating garbage.
And we can help you today. We can help you with your own stuff. And we can help you with what we got some other stuff going on.
Okay, we can help you today. We can help you with the other stuff you got going on. As we talked about, he has a probation violation. He's been arrested for that. What is
I was
that?
on the jury. It would have been a hung
It's a
jury. I'll
promise
tell
of
you that.
leniency. They're saying we're going to help you with other stuff today.
You could play clip G9. This is right about 16 minutes into the interview.
Absolutely. You bring value to our case. You do. And it's important that you take advantage of that. Because the opportunities they're fixing to go away. Because we are moving forward.
All right, what about telling him the opportunities are going away?
So there are two things here. First one is that they're telling him that it's in his self-interest to do this because opportunities are going away. The second part, and it could go either way, could be seen as an implied threat because if the opportunities are going away and the opportunities that they've talked about are helping him out, which they've talked about several times in here, if that's going away, there's an implied threat there. that if he's not on their team, that the full
true.
weight of the law is going to come down on him.
It is the best one.
Okay, and now at this point, we're about 15, 16 minutes in. They still haven't asked a question about any information you may have. If you could play clip GD, as in dog.
So I guess I would call it a deal of a lifetime.
And again, that would be a promise of
It's emphasizing the seriousness, right? This is a deal of a lifetime, and there's also a promise of leniency with a deal.
Okay, about 19 minutes in is when they first asked him what he was doing on July 3rd. You recall that, Professor?
Yes.
And if we could play clip G27B as to the first thing he says about what he was doing on July 3rd of 2015.
Yes, I went to Redwood. Yes, Michelle. Yes. For July party, which was a pre-party on the third. Okay. Set up for the party from 4.
Okay. You left.
Yes, sir.
No, just things, I don't care how I'm guilty of this. And we already got, obviously, you're here
And
for
my
me.
daughter was with me. I was riding with my daughter.
Yes, sir.
Tammy Gardley. We left. I went to Brooks Houck, got my money from working for it that week. And then we went back to Candace for a little bit and went back over to Brandon Shields.
So the first statement he makes, does he provide any information, any incriminating information? About
No. He says he goes over to someone's house for a pre-party with his daughter.
Was that accepted?
No.
You could play clip G8, which
Oh yeah, he was the
Right
pre-party,
after
the
this.
party, the after party.
yeah,
Always a party.
GJA, please.
Mr. Kirby,
Yes.
all right, I want you to, like, we already know everything, okay? Like, the whole shebang, okay? We've got multiple people in custody tonight. We've got teams out on them, okay? And we have several people, okay, talking about your involvement here, okay? All right? We're not after you. We're not gonna hold you.
All right, what's the problem with this?
So a lot to unpack there. First is there's the emphasizing evidence, right? So they're saying we know everything. The implication is if your story deviates from ours, it's going to be rejected. There's information degradation, meaning they're saying his information is incorrect. The reason you get that is because he just gave a story, and they're saying this is right after that one, correct, right?
Yes.
And they're saying, look, we know everything. The implication, of course, is that the story you told us is not right. And then finally, they have the promise of leniency that they're not going to charge him, so he should feel free to say the story. And also, you saw there that he put his hand on his knee.
Now, after that, if you can play the clip G17.
We're not after you. We're not gonna hold you.
Here's what you read my mind on.
Dear friend.
Okay. Like I said, we did. Brooks Houck ever speak to you about picking up a car at all?
No, sir.
That's an important point. I want to stop there and go back. He's told them what happened that night, correct? It's up
Yes.
to this point. They have not accepted it, correct?
Correct.
Mr. Girdley has been told at this point that we're not after you, it's a deal of a lifetime and other things. I'm not going to go back through all, correct?
Yes.
Now, what's the question that Mr. Girdley asked him in that clip?
What's my involvement? What do you mean by my involvement?
Now, what does Detective Luckett say in response to Mr. Girdley's question?
Did Brooks ask you about with Crystal or the keys? I don't remember exactly.
You could play that clip one more time because I think that's important.
We're not after you. We're not gonna hold you.
Curious what you made my mind Lawson.
Okay. Like I said, we do. Brooks Houck ever speak to you about picking up a car at all?
Okay.
Okay. Detective Luckett, is this the first time in the interview that Mr. Girdley, anything has come up about Brooks Houck and this car?
Yes,
And who brings it up?
Detective Luckett.
And what was Mr. Girdley's answer when he was first asked, did Brooks Houck ask you about moving a car?
No, sir.
Okay. Now, shortly after that, if you could play clip GB.
I promise you, this was your once-in-a-lifetime opportunity. Sometimes the Lord smiles on us, and sometimes when it's bad, it can become good.
All right. What's the problem with this? Now we have the story. Now we have Luckett suggesting that Brooks Houck asked him about a car. What's the problem with saying this is a once-in-a-lifetime opportunity?
So two things. It's your comment. It's in your self-interest to tell us a story, and it's a promise of leniency.
If you could play clip 28.
I'm cool with what you're doing. I'm just going to ask him to quit leading so much.
I'll try.
I mean,
Yeah, that's fair. Thank you. So if you could play clip 28, please.
I'll take care of it no matter what. All right. And I'll have the prosecutor here, and I promise you that we will walk you through and make sure we protect and take care of you in every way. All right. And you have to believe in it and your family. You and your daughter, okay? We will do everything we can to make sure that everybody's okay.
Okay, can you explain the issues with that?
So there's a promise of leniency. We're going to do everything we can to take care of you. They also bring up his family, which is a social psychological manipulation, saying that they're going to take care of his family, right? The reason these are manipulations is because they're all contingent on him telling the story that they're looking for.
Okay, if you could scoot up
I'm
just
sorry.
a little bit, that's okay. And at this point, approximately 25 minutes into the interview, if you could play clip G18A, please.
How did you get involved?
I mean, I'm not getting involved in it. I'm probably said something like that, take your call up.
Okay.
Like that anymore.
What did he say?
And he just said that all of them told his beaches. And asked them to try and shit to come pick it up. And came back and tried it. I went to pick it up. And he said, I'll shit and word that out. It's nice, grab it.
Okay, so at this point, 25 minutes in, is that the first time you hear that Brooks actually asked him to do something with this car?
Yes.
Now, I'm going to skip ahead and we're going to come back. If you could go about an hour later, please, Sandy, to 1 hour and 18 minutes into this, if you would play clip G19 for us.
Brooks doesn't get me back to call and tell me. If anything,
Okay, so an hour later, did he change his story?
Can you play it again, please?
Yes, sir. He played G19 again.
Brooks doesn't get me back to call and tell me. If anything,
So did that contradict what he said an hour previously?
I believe so, yes.
If you could go back to clip GA1. This is at the beginning of the interview, about 4 minutes in.
Let me tell you, you cannot be a witness for us in any single way. Okay, we lose you if we don't have that credibility.
Did they end the interview when he changed his story an hour and 18 minutes in?
No.
Now let's talk about the kind of the second fact-related thing that he gives in this case. And that's about, and we heard a little bit of it in one of the clips to just orient you, Professor, about the Lawsons talking about moving the car. You're familiar with that from this, correct?
Yes.
All right. So if we could go back to about 17 minutes into the interview, we've heard a little bit in some of the previous clips about arrests. If you could play G29 for the jury and this professor, please.
We've had another individual in custody. I won't say exactly who, two individuals. No, I won't say that their last name's Lawson.
So who provided information about Lawson's being arrested?
Detective Luckett.
All right. Now to go back, to get us oriented back, at 25 minutes into the interview is when Girdley first says, I asked him to pick the car off. Brooks asked him to pick the car off the Bluegrass Parkway. Did they accept that?
No.
If you could play clip G8, which is 26 minutes or so into the interview.
You should be able to have a good life. I want things to go forward for you, man.
If you could play clip G20 before I get to the next question.
What I can do is tell you, today is your one and only opportunity to get ahead of this and to be on my team.
At G26.
Why we're here today, man. Giving you a chance, giving you an opportunity of a lifetime here, because this is a pivotal moment in your life.
Let's kind of unpack those. If you could explain those to ladies and gentlemen of the jury.
So they're saying to him that this is in your self-interest, right? It's in your self-interest to do this. If you don't do it, other things are going to happen to you, so you might as well come and tell us what we want to do.
If you could play clip GK, please, and then GE after that.
We want to get you back with your family. We want to get back with our family, okay? And we want this to be hush-hush for now. And that's how we can try to help get you out, whatever. It does no good for you to sit in jail for us.
You don't want to be on the wrong side of this when the gavel is coming down. I'm telling you, it's coming down. And it's coming down quick and hard. And anybody and everybody that has any involvement that doesn't want to be on my team is going with it.
Okay, these are separated by some time. And we can't play this whole interview, but can you unpack those two clips for us?
Okay, so the first thing is with his family, it's self-interest, right? That telling a story will allow you to be back with your family. The second one is implied threat and self-interest, right? The gavel's coming down for people who aren't assigned. And the other thing it's a thing that we code as belligerence, when people start showing frustration and banging on the table and stuff like that when they're not getting what they want from the person.
If you could play GF, please.
This is the most pivotal moment in your life right now. You are a 51-year-old man that could either spend the rest of his life in the penitentiary, or you can help yourself and walk out of here. This is a pivotal moment. You and only you can take advantage of this. I can't do it for you. I want to, because it would help me. But for your sake, it has to be from you. You have been carrying this around for 8 friggin' years. I know you're exhausted. I'm exhausted with it, Charlie. And I've only been working it for a few years. Man, I am telling you, this is your moment. And if you don't take advantage of it, I have to walk out this door and move on without you. And I can't. And unfortunately, I will. Okay? You gotta come off of this, man.
Okay, you can explain the multitude of problems with that.
So you see that he's invaded his personal space. He's up on top of him. He's got his hand on him. When you get that close to people, it makes them feel anxious and more vulnerable. Secondly, and probably the strongest thing in there, is the threat of inevitable consequences. You heard him say, your choice is to do this, which I assume what he means is telling him the story that they want to hear because they haven't heard the story up to this point that they're looking for. And his other option is the threat, going to the penitentiary for the rest of your life. And then they say with all the other stuff, it's in your self-interest to tell us this information because those other consequences, the implication is the other consequences will go away if you do.
At this point in the interview, have they heard that the investigators are interested in Crystal's car being moved?
Yes.
And at this point in the interview, has he heard that the investigators have arrested Joey and Steve Lawson and are interested in that?
Yes.
So that clip was, to orient us, about an hour, 16, 17 minutes into the interview. Did you play clip G21, which is about a minute, hour and 19 minutes in?
To my knowledge, Joey
Oh, we're still on this.
did say he did move the car. Where to? I don't know.
Professor, is that the first time he made any mention that Joey and Steve moved the car in the interview?
To my knowledge, yes.
Now, the next statement or topic of interest that comes up is how Joey got keys from Brooks. Are you aware of that from reviewing these interviews?
Yes.
You could play clip G11.
You and Joey leave together again. Okay, this is where we know what's happening, what we're trying to lead you into. For your sake.
Can you explain what the problem with Detective Luckett's statement there is?
He's saying we're trying to lead you into the information, rather than allow him to come up himself. I think he says before this that we already know what's happened as well, which is an evidence tactic saying that we know the information.
Play clip G7, which is a couple minutes after that, please.
And that's what I'm trying to do. I'm trying to remember correctly.
Okay, this is what Sage called.
All right, can you explain what the problem with saying this is what saves Charlie is?
They're indicating what information that they want Charlie to provide in order to get whatever they're going to give him.
If we could play clips G59 through 62, which is
I don't know if I'm recalling right or not, but I'm thinking that Brooks got some keys.
I think you need to remember specifically where he met him and how this went down. This is so important, Charlie. You have to remember how this went.
And that's what I'm trying to do. I'm trying to remember correctly.
Okay, this is what Sage called. Okay.
Yes, this is Charlie Girdley they're interrogating. We watched when he took the stand. And, oh boy, that guy.
Kitty had the 14-15 type of drive at that time. Comes up with was, oh yeah, when we put my friends there. enjoying the kids.
We're not trying to get your family, but we're gonna get
No,
one.
no,
We're gonna get one to say
I'm just trying to recall.
we'll take care of it. Any family members of yours are taking ours?
Kids.
Okay.
Yeah, just remember it's like these interviews, Charlie, Steve, all of them that all happen at the same time with these kind of tactics that all of a sudden they solve the case.
We don't need to believe, we need to think and remember exactly how this went down. There's a reason you're saying somebody else might have been there to just remember exactly who the person was and how you all got it. Remember exactly where you met him. Or met who met her. You need to remember who, what, when, where, how. Okay. We're not gonna put words in your mouth. We know this, and we're not gonna put words in your mouth. We can't. Go ahead and have you say. Yes, sir. All right. Yes, sir.
Because I drank back then and everything.
Yeah. You and I both.
But I didn't really like I said, later 62 years of joy and the dick of kids.
Okay.
Because kids
Oh, yeah,
really
Angie.
were
Listen like Angie.
going through divorce. Somebody was
Really
split up,
catchy.
separation or something.
Mm-hmm. And when police do stuff like this, that means they do not have somebody dead to rights. Because if they do, they don't need to talk to you. So whether you are a witness, you're innocent, you're guilty,
I wasn't sure Brooks
don't talk to the cops.
coming out the case
Settle fair,
and
no matter what.
asking Joe that Brooks got to the keys from me.
And be more like
You have to remember specifically how it went and where you all were.
With that case, when people can cut the drive.
also a tactic, a big tactic.
All right.
Now, granted,
Who was
we want
present for this
on
exchange?
the other side of
You
the
know that?
Yes, sir. He was there. There was someone kidding me.
What's his name?
Tattoos.
What's his name?
I just admitted one time he
What's
was
he look like?
he
I saw you the other day.
Done tattoos.
Hi.
kidding.
What do they call him?
You're doing well.
Switching out.
Still normal. Did he see? Did he see Brooks?
Brooks came in the house for a few minutes. Came into the living room.
What did they say?
He was pinching keys to Joe. He said, "Here's your keys."
Okay. All right. Then what?
They talked, got up there back for a few minutes. We left.
Okay, was this accepted?
No.
We could play clip G6.
I do
I need to know the whole
appreciate them
story.
having
All
all
right, I'm gonna help
this
you. Charlie, I'm gonna help you. Let's just stop for a second. Just listen to me, okay? I don't get out of bed for just anybody, okay, or anything, all right? I come here to help you, okay?
And G15.
Mm-hmm. It happens a lot.
Let me help you, all right? I'm extending my hand to you, man. Grab it,
Same.
okay? Because I'm gonna be able to pull you up out of this, all right?
I'm trying to win the world I've been in. I'm trying to
And I'm gonna help you, but you gotta help him, okay? I'm gonna take care of you, Charlie, but help him, okay?
I've also never seen a prosecutor
And if you could play clip
in an
G11.
interrogation room.
Or GL, I'm sorry.
When I tell you I got you, all right, tell me I got you. All right, and I'll walk to that prosecutor and I'll do anything I can. But we have to have the whole truth. I don't give a shit if you were the one who killed her.
Okay, let's kind of unpack those three clips. If you can explain what's wrong with those.
So The first part was information degradation, telling him that a story is not right and what he needed to tell them in order to get whatever he's going to get in exchange. You heard several times, remembering it's going to save you to remember this information, and thinking it is not enough. We need a definitive statement from him. And then you see that there's promises of leniency and emphasizing the seriousness of the case, right? I don't get up for everyone. And then there's the quid pro quo in there, which is one of the things that Reed talks about you shouldn't do. I'm going to help you, the offer of leniency, but you have to help them first. Right? You're not supposed to do that. Can you play that last clip again? I can't remember all of them, sorry.
Yeah, if you could play GL again, please.
When I tell you I got you, all right, Elliot, I got you. All right, and I'll be a prosecutor and I'll do anything I can. But we have to have the whole truth. And I don't give a shit if you were the one who killed her.
Okay, so there's promise of leniency in there. And then also, according to Reed, you shouldn't tell people they won't be prosecuted if they've committed murder.
Right.
After all this, did the story change about 30 minutes later?
Yes.
Now, if you could play clip G66A.
Me and Jordan look up to Copperfield subdivision from my room.
Explain that, man. Like, what's the timing on that?
Or can you get that in on it?
What vehicle was he in?
He was in his work truck as he was finishing pulling up a driveway vehicle for the next day. He was finishing up pulling the driveway up, and he was going to pull it next day.
On the night of July 3rd?
I'm almost positive. Because when you go back to the back of the subdivision, not the very back part being got going on now, that used to be the middle section of it right now, which is the back building. I knew exactly what else it was on the driveway up here. I'm positive that's where we met in that Copperfield subdivision.
Okay, we've heard at this point Mr. Gurley say that he met Brooks at 10:30 at night at Copperfield subdivision. Was that accepted?
No.
Okay, if you could play clip GC as in Charlie.
You got
I know that.
all right. I'm just gonna don't respond. Okay. I want you to sit here and I want you to think long and hard about where Charlie Gurley is in life and where you are in reference to this case and why you're here today. You need to be thinking about that. You need to be thinking about what Detective Bucket and I need from you in order to allow you to be on our team. That's what you need to be thinking about.
So what's wrong with that, Professor?
So he's saying it's in his self-interest to remember to tell, I guess that's Hardin, what he wants to hear.
And there are times and after this,
Roll with
an
the top
example
down.
where investigators leave the room and tell people to think about
I
it.
miss you, Savage.
Can
And
you
your
explain
wit.
how that impacts the course of interview?
It's not necessarily a terrible thing to take a break and leave the room and ask them to think about things, but you have to remember this is coming after he's given 2 stories that have been rejected. So they're asking him to come up with a 3rd story.
This bailiff behind him's like,
Play
I can
clip
get
G72, which is about 3 hours and 18 minutes into the
I don't think he
interview.
should be sitting there.
So why did Joey come pick you up?
Because I called him, asked him to come pick me up, give me a ride over to Brooks so I could get paid. Brooks paid me in cash that night. We went over to Woodlawn Road to that subdivision over there, where we were framing houses.
Mr. Brooks normally pay you late at night.
And he did that night, it was like 7:30, because he wasn't around when we got off work.
Okay. Was that story accepted?
No.
And if we could play clips 74 and 75, just play them together for speed purposes, please.
I'm confused about some stuff, okay? Not saying you're lying or anything or wrong. I need you to think real hard about and think about it. Where you and Joey said went and picked up your money, right?
Right.
Brooks, and the keys, right?
And from Woodlawn Road.
Think about where you picked it up at. Because you said it was around 8 o'clock or so?
It was probably between 7 and 8 o'clock.
Okay. I just think, think real hard about where it was, okay? And here's what I'm telling you. I know where Brooks was at that time, okay? And Tom's right. It's just, I'm trying to figure out exactly if you're having trouble remembering where you picked them up. I need you to think about it before you answer me, okay? I think you're right about the time, okay? It makes sense with what I know, okay?
Okay.
I'm just not sure about the location.
It's been 8 years ago.
I understand.
I can't remember.
Here's the other thing.
I can't remember. I can't remember it was one of two places.
Okay,
It was either his house he Creek Chase, or it was out there at the house we were framing in that subdivision right there on Woodlawn Road.
Is there a problem with suggesting I agree with part of it, I may not agree with other parts?
So there are a couple things. So first of all, that's information degradation, right? He's saying that the information is wrong. And then there's the evidence tactic, which he's saying he already knows things are going on. In addition, as you guys probably saw, there was some post-event information slipped in there. Originally, Charlie said it was from 7 to 7:30, and now it suggests that it was around 8 o'clock, and he accepted that. So he responds, oh yeah, it's between 7 and 8 o'clock.
Now I'm going to switch gears to an interview on September the 15th of 2023 between Mr. Girdley and Kentucky State Police. So we've heard evidence in the case, Professor, that Mr. Girdley testified that he was asked to do something to Crystal Rogers and he rejected that. So if you could play clip G25 for us.
At one time, Steve says, and this is not one to get you in trouble, okay? So just be honest about it. Steve says Brooks asked him at first to actually take care of Crystal Rogers and kill her. He was like,
I've never seen somebody so uninterested in their
He's
job.
like, that wasn't me.
Right.
Yeah. He was like, that wasn't me. He was like, I told him I'd still help with the car. And he was like, but. He said, I did. He was like, I told Charlie. He was like, I told him maybe Charlie. He was like, Charlie would do anything.
No, Charlie didn't do nothing.
No, but listen. Here's what he said. He said that he just said it to you. He was like, I just told him. He was like, I told Brooks you. And he's like, you just laughed at him.
Yeah. So
But no, I need to make sure that he
We're trying to verify that the conversation
took place.
took place.
and I mean, I thought it was a joke.
Is there any problem with this?
Well, they're just suggesting information, asking if what happened, and he's agreed to. Sorry,
That's
they're
okay.
giving him the information that happens, the evidence, and asking him if it happens.
Now, you also reviewed Heather Snellen's
Correct.
statements. And we heard testimony that she overheard a conversation with Joey Lawson, Steve Lawson, living in
Mr.
Ohio.
Butler, I'm sorry to interrupt you. I've got some jurors indicating they're ready to take
Yes.
a break here. So Ladies and gentlemen, we're going to take a 15-minute break. The same admonitions are in place. Do not discuss this case among yourselves. Do not let anybody discuss this case with you. If anybody tries to.
All right, everybody do their quick stretches because we get to miss the breaks.
And you're not to finally make up your mind about the case until you've heard all the evidence, received the instructions from the court, gone to the jury room to consider what your fellow jurors have to say about the case. You may go with the title. You start back in 15 minutes.
This makes me so annoyed. I'm actually in the middle of researching a case for True Crime and Wine Time where the perpetrator has been given a new trial because of coercive BS like this that's happened. It's very fascinating, but no spoilers. It'll be out in a couple of weeks. And I think I don't think the guy that did it, that they say did it, is the guy either. Some of you may have heard it. You guys know Eaton Katz. He was the little boy from the milk cartons.
At this time, with the record reflects,
in the
all
80s, you remember?
15 jurors have returned to the courtroom.
We used to put
Counsel
missing
waived the
children
call.
on milk cartons.
Yes. Everyone may be seated. Thank
It's
you.
his story.
Sir, you're still under oath, okay? Mr. Butler, proceed when you're ready.
Yes, Professor, if we could, I think when we left off, we were getting ready to switch to Heather Snellen's interview in September 23. Jury's heard testimony that she overheard a conversation, according to her, where Joey and Steve Lawson moved the body. If you could play clip S12, which is about 14 and a half minutes into this 4.5 hour interview.
Your life's going pretty good right now, right?
Yes, sir.
I want you to keep it that way.
Keep it that way.
I can only do that if you help yourself.
Yes, sir.
Oh, we did not
If
see
you play clip SA, please.
Okay? I'm gonna take a break, and I'm gonna let you think about stuff.
Okay.
And you probably need to have some answers for me. Okay?
Okay.
I know you know more.
Uh,
I know you know more. I know you know more. There's no sense for you to hold on to what you're holding on to.
I don't know what else.
Okay, what's wrong? Let's unpack those two.
So this one is information degradation, right? They're saying that she has more information. The information she's giving is not correct. Could you play the first one again, please?
Sure. Clip S12.
Your life's going pretty good right now, right?
Yes, sir.
I want you to keep it that
I'm gonna
way.
keep it that way, too.
I can only do that if you help yourself.
Yes, sir.
So it's in her self-interest to give him the information that she wants to know, and there's an implied threat there.
Mm-hmm.
Could
A
play
very
clip
big implied
S1.
threat.
The best friend you have right now. I am the best friend you have right now.
What's wrong with that?
He's misrepresenting his role as a friend rather than a police officer.
Could play clip SB.
You need to decide whether or not I'm going to roll the dice, and this man's telling me the truth, and I'm walking out of here, and I'm going to have a life with my little boy, or I'm going to hold on to what I got, and I'm going to get caught up in another spider web with Joey and Steve Lawson or whoever else is involved, and I'm going to drag it down and potentially have my life not have the same outcome it would be had I just come off of it.
Okay, what's wrong with that? We're now 35 minutes into this, 36 minutes into this interview.
So that there's the self-interest, right? You have to do this for me if you want to continue to have your life and be with your son. And then there's the implied threat that if you don't do this, bad outcomes could ensue.
Play clip S3.
The most high-profile case in Kentucky's history has garnered national media attention.
What's wrong with bringing that up in an interview?
It's again emphasizing seriousness. Once again, if the crimes are more serious, the punishments are more severe.
Now we're gonna, if we can, say to go 59 minutes into the interview. If you could play clip SC.
I know you don't know. I'm gonna get up. I'm gonna take a break. And I'm gonna give you about 5 minutes of self-reflection of where Heather wants to be in her life. If she wants to be lagging back with Steve and Joey Lawson in drug addiction, or if she wants to be Heather who works for a phone company, who's raising her little boy, who's cute as a button.
Can you explain that?
So the first one's information degradation. The information that she's given, she's told is not correct. Secondly, there's an implied threat there. If she doesn't come across and think about this information, she's going to be back with the Lawsons in drug addiction. And then there's the implied threat that if she doesn't give the information, she's not going to be able to be with her child.
Which is pretty powerful.
After that, did she provide information that she didn't have any information multiple times throughout this interview?
Did she say she didn't have information multiple times?
Correct.
Yes.
Was that accepted?
No. Decidedly not.
Clip SD.
Okay? Are you satisfied with the information that you gave me? And are you ready to end this interview and us get up and walk out of here and leave it like this?
I want to say yes, but I want to say no because
Okay, let me ask you something. Why do you want to say that? Because if you told me nothing but the truth, and there's nothing more
that I can recall.
Let me finish. If you told me the truth, first of all, let me tell you something. Do you know that we use that, like I'm probably telling on the police world right now, that phrase that you just said is how we determine who lies.
What's wrong with that?
There's several things. So first of all, if this is a non-custodial interview, when the read says that you shouldn't block the entrance for them to get out. Non-custodial means they're free to leave at any time. If this is a non-custodial interrogation or interview, you're not supposed to leave. There's obviously information degradation going on, and telling her that the information that she has is not enough, and she has to come across with more information.
You could play clip S13.
There's information because I'm tired of throwing stuff out of you. Like the next step is probably you're going to be on a grand jury. I'm not in control of that. But do you want to stand up and swear to your testimony up there that you're not going to be caught in a lie and charged with perjury or anything else?
And what's the problem with that?
So that's a threat that if she doesn't tell him what she wants to know, she's going to be charged with perjury.
Now we're about an hour and a half into this interview. To play clip S4.
Let's keep our focus on the grand scheme of things. Whenever you decide to come off of whatever you take, whenever you make that decision, then I know we're going to be done, and guess where you're going to be. Where are you going to be at? That'd be awesome, wouldn't it? Do you know where I want to be at?
Thank you, party with your kids.
What's the problem with that?
Two things. One is it's information that she hasn't told them the truth yet that they want, and the second one is her telling what he wants to hear. I believe this is Miller, if I'm not incorrect, is contingent upon her access to her son, which is one of the things the read technique says you also shouldn't do.
I remember she wrote a letter a couple months later
Shortly
to them,
after
being
this is the first time that she
I don't know
makes any
anything.
reference to saying she overheard Joey Lawson and Steve Lawson talking about moving by.
Correct.
Did that end the interview, that statement?
No.
If you could play clip, at some point it switches to they murdered Crystal Lawson. Could you play clip S5, 2 hours and 8 minutes or so into the interview?
Listen, every time I press you, you get something different. Is it worth being wrapped up in for your son?
No.
Let me help you. Come on. I'm trying to help you. Why do I have to pull this out of you? Don't be that way. Don't be that way. It's too far to go back now.
You let me get that far.
Do you know why? Because I'm tired of being lied to.
I'm not lying to you.
Hey,
So there's
If you could unpack that one.
there's a lot there. First of it's belligerence, right? When they show frustration, bang on the table. He's accusing her of lying, which is information degradation. And he also says, you know, it's in your self-interest. If you want to be back with your son, you'll stop lying.
At some point, does Detective Luckett, who we saw so much of in the Girdley interviews, become part of this interview?
He does.
If you could play clip SE, which is 2 hours and 25 minutes or so into the.
Oh, I thought he was about to say it was 2 hours. I was like, what?
We don't care how involved you think you are, okay? That does not matter to us, okay? That's what I want to reassure you. Let me, before you say further, okay? Well, we got it, okay? So before you say further, okay? We all make mistakes in life, correct? And I'm at a place where I've made, okay, I've had to ask the Lord. I've asked the Lord for forgiveness many times in my life, okay? All right? But what I want to tell you, okay, is no matter what you think you are culpable of, okay, we don't want to prosecute you, okay? Now, it's important to do the right thing, and I know that you're a good person deep down. I can see that in your eye. Okay, I can see it in your eye. It is important, okay, that you come totally truthful, no matter how culpable it makes you look, okay, and your involvement, okay.
Can you address that, please, sir?
So the first thing is a promise of leniency, right? Whatever you do, it's better. And then self-interest. It's in your self-interest to do this. And then complimenting her, right? You're a good person. I can see that, which is one of the tactics they use, because what do good people do? They tell the truth. And then, of course, there's information degradation. The implication, of course, is the stories they heard before are not the truth.
If you could play clip SF.
Sure, we do this, okay? I don't care if you were as a trigger puller, you're not going to jail today.
What's wrong with saying, I don't care if you're the trigger puller, you're not going to jail?
So it's a minimization, right? It's saying that your consequences are going to be minimized if you come across with a statement that we want to hear.
And if you could play clip SG.
Okay, you have a sign, I do not want to see anybody get hurt, I do not want to see you go to jail, okay?
And that?
That's an implied threat of inevitable consequences, jail time.
And she's done time before.
At some point, she's offered immunity, correct?
So
Correct.
for her, that's a very real
Means I won't
possibility.
prosecute you if you cooperate, correct?
Correct.
Even
Now,
though they
if you
didn't have
play
the possibility at the time. But
S6.
You're a good mama. I can tell, mama, so I can tell. So remember him when we're talking about this.
What's wrong with telling her to remember her son when we're talking about this?
It's a social psychological manipulation. First, there's the compliment, you're a good mother, right? Then there's the manipulation saying that remember your son. In some ways, you know, your son will think more of you if you come across with whatever information they're looking for.
And if you would play clip SI, please.
All right. That little boy right there that you was talking to, okay? That's your life, all right? No matter how hard it is to say and to bring yourself to, okay? For him, okay? For him. Okay, he depends on you to hug him every night. Okay, he depends on you to be there. Okay, Did you hear the way that he was? Did you hear the way that he was talking to you on the phone? Okay. If you hear the way that he's talking to you on the phone, bring it home. Okay. Bring yourself home to him every night. All right. Let it be done. Okay. We've got you, Heather.
I understand.
Okay. You're still holding back, and I can tell. Okay. All right. This is clear. And this is all going to come out. Please. Please. Like I beg you. Okay? Don't hold back. Beg you. Bring it all the way home, Heather. Please. He depends on you. All right? Anything that you say, like Mr. Young said, goes in that box.
Oh, her sweater says
Okay.
boy, Mom.
Don't hold back now. And you are, and I can tell it. Okay? I'm going to be brutally honest with you. It's what I've done for 25 years. Bring it home. Please. We'll take care of Steve and Joe. All right? Don't put yourself in that boat. Like I can hear your little boy. He loves you. And I'm begging you, from me to you right now. Begging you. Don't do that to him. Enough little boys are with that for mama.
You know, and she's just supposed to be like a witness.
You explain that one for us?
So there are several
Gets
things.
treated this way.
One is the allusions to the child can be seen as a social psychological manipulation. Do it for him. He needs you. All this stuff at the end, when she says go home for him, can be seen as an implied threat that if she doesn't do it, she's not going to get the promise of leniency that he talked about in there. And the last thing that was in there that I recall is leveraging his experience to say, I've worked this for 25 years, so I know all of these things. I'm the expert in here, so she should take his advice.
This next one, she did not testify to a trial. But did they get her to make another incriminating statement at this point?
Yes.
If you could play clip 17A.
They killed her shoulders. I honestly don't know how, and I don't know if she's had it
How do you know this?
because they both did it before they killed her.
What did they say?
That was just about it.
How did they say?
They just said that they killed her.
Okay. How did they say they did?
They didn't.
Okay. How did this conversation go through the whole conversation?
It was literally just a, like I said, kind of back and forth conversation, and then it come up. It slipped, I guess, in conversation. Getting a little too drunk, getting a little too high, and then it kind of just slipped. And then
What were their exact words?
we killed her shoulders.
What did you say?
I said, do what? And they said, oh, no, that's not, no, that's her. No, I don't think they did.
Did they accept this?
No.
You could play clip 7. That was 3 hours and 20 minutes into this interview. Let's go to clip 7 or S8. 3 hours and 52 minutes in this interview.
I don't want you to leave here and not have told us the truth. And then I think that dinner would probably be somewhat irrelevant if we leave here and we're not on the same page.
What's wrong with that?
So the dinner she's talking about is the one that she's been trying to get to through the interview with her child. And it's an implied threat here that if you don't tell the truth, that you're not going to be able to see your child.
Remember, she can leave
If
at
you
any
could play
time,
clip
but she doesn't
S9.
know that.
Okay, that's why we're still here. You still know more. You still know more. We're still sitting here, and you're still away from your son.
What's wrong with that one?
information degradation, saying that she hasn't told her the information and that telling them the information is now contingent upon seeing her son.
And if you could play clip S10, which is 4 hours and 12 minutes into this interview.
Think that that's your little
At
boy.
this point, I want to leave. Period. I feel like
That's
I'm
fine.
a person in a corner and I'm like,
You know what? If you want to roll the dice, get up and get out of here. Because if we find out anything else, then you'll have to deal with the prosecution. And we're trying to help you.
I don't know anything. I want to go home.
Here,
I want to go home.
listen.
I want to go home.
Listen.
I'm going to home.
Can you listen to me for 1 second, please? Listen to me. All right? Listen.
Still not letting her
Okay?
out of the room, blocking her from getting out.
Do me a favor. Okay? Take a breath and listen to me for a second. Okay? Can you do that for just 1 second? So that I can.
I'm seeing her.
So here's what I'm asking. Okay? I do not ever want to come forward, okay, and take you from your little boy or anything else, okay?
What's wrong with that?
So there's several things. First thing, according to the Reed technique, you should never not give someone their constitutional rights. If this is a non-custodial interview, when she says she wants to leave, she should be allowed to leave. She was not allowed to leave, right? They stepped in front of her and said that. The other thing, as the other officer is leaving the room, he makes a threat about what her consequences are going to be if she does leave. And finally, the last bit is that there's an implied threat that I don't want to take you away from your little boy, meaning that if she doesn't come across with information, if she doesn't come across with the truth as they want it, that she may lose access to her child.
Professor, we're just about wrapping up. What's the danger of these types of coercive tactics?
That people will give false statements.
And in the course of your career, you've reviewed, I assume, multiple interviews and interrogations.
Yes.
I mean, can you give us a rough estimate of how many you've
25, 30, something like that.
cases you've worked on?
Overall,
Yes. How many?
over 100.
Where do these two interviews rank in that as far as coerciveness?
These were some of the most coercive interrogation tactics, interview tactics that I've seen. The threats, the promises of leniency, the threats to take her away from the children, are all things that even the Reed technique would argue that you should not do.
All right, I think that's all the questions I have at this time.
Any cross?
Yes.
I mean, that's the thing with all of these witnesses. You can think that they're telling the truth. Maybe they are, maybe they aren't. But the way they got to it negates all of it. You should throw it away because it's been tainted by the investigators. I found Heather to be very credible. I really did. She seems she's really changed her life. But
clip line placed was they were telling Charlie that they'll protect him and his family. What had come up was Charlie was scared of the Houck family, and so I'm gonna tell him. He wasn't telling them they were going to protect him as far as like not going to jail or anything. They were protecting him physically because he was scared. Tanya, his daughter, also protect him and his daughter from the Houck family. So I think I should be able to ask about that to put it in context.
I think he should be able. I think he can ask something to the effect of, do you have any idea if he was concerned about witness safety? I think that's an issue in every homicide case. But he can.
So what are you wanting to
I'm gonna say prior to this, they were telling him that they would protect him from the Houck family.
I think he can say, I didn't open that door. Well, it doesn't, because you open the door doesn't mean we start talking. I don't know that I've opened any door.
And I would object because I haven't opened any door. And that should not.
Y'all have a joint defense agreement.
So, okay, guys, I'm just trying, is there talk on the tape about protecting from the Houck family, or is that?
I don't know exactly. I'll let Shane answer
I
that
don't
one.
know exactly. I really don't. I do know that when they told Heather, I got it written down over there, that she specifically expressed that she was scared of Steve and Joey.
And Joey once told her that he was going to put her in a hole. She said that phrase is,
Y'all aren't letting me talk. Y'all keep talking.
I'm sorry.
I think it's fair comment to say, is it, can a witness be concerned about safety? Is that something that's appropriate to talk to them about? But getting into how scared you are of other people or what, that's, you can't.
This is all being taken out of context. She has specific people that she's concerned with.
That's not, the point of it is what he's saying is, this is, in my opinion, y'all gonna let me talk?
Go ahead.
In my opinion, these tactics of saying we're going to take care of you is coercive. I think it's appropriate cross-examination to say, if a witness is scared for their safety, there's nothing coercive about saying that they'll help them, and he can say yes or no. But going down the road about a bunch of stuff that other people think in their head.
So she's giving statements about these individuals, these direct individuals that she's saying she's scared of. And it goes to why she may be withholding.
You're talking about Heather on the recording was telling she was scared?
Yes, because Joey told her, after Joey said that in front of her, he told her he would put her in a hole.
I mean, Joey is a scary dude.
Number one, I think he can,
record proves that.
He can ask about witness safety as it relates to. Y'all done?
No, she was talking
about. Oh, okay. I think it goes to witness safety. He can ask the question, in your opinion, is it coercive if a witness is concerned about their safety? Is it coercive to say, we're going to take care of you? And I don't know what his answer will be, but he can answer whatever. But to the extent of going down this road of throwing out a bunch of, of inflammatory statements, the prejudicial effect of that is certainly outweighed by any probative value of just saying it's okay to tell a witness we'll take care of you if you're concerned for your safety.
I'll speak.
Yes.
Okay. Let me. She's withholding statements about these individuals because she's scared of these individuals. That's why they're telling her to protect her. That's why she's withholding these statements. That's why they're having to drag these statements out of her, because she's scared of these people. And I think that's relevant for the jury to hear.
And I think it's a fair comment to ask the question, if she's scared of them, can that be a reason that she might withhold information? That's fair comment. Start throwing out inflammatory stuff about the Houcks or Joey's, these extrajudicial statements that Joey Lawson's made, I think is taking that point too far.
Well, I'll allow you to ask questions about if the person's scared of people involved, can that be a reason they're withholding information along that line? Now, if you want to get into specifics, let's come back up to the
Can I ask this? Okay. Can I ask, did she express fear of Joey and Steve Lawson?
And she does, I'm assuming.
Yes, sir.
That could be a reason why she's with them. I'll allow to that extent.
Okay. Thank you.
I mean, I'm sure she's afraid of Joey. Joey is a huge piece of shit. He had quite the record of being an abusive POS. Mostly against women.
Good morning. Good morning.
And I think Heather was one of the two that
Yes.
charged.
I gotta get my glasses.
Oh, no, wait. Heather didn't have a baby with him. That was Elizabeth.
So I found out something the other day, and I don't know if you were told this or not. Okay. Mr. Girdley, at the time he was arrested, had been up for approximately 5 days using methamphetamine. Could
To the shock of no one.
Yes.
Okay. And could that also be a reason why he was confusing facts?
I'm not an expert on that, but usually they recommend not interviewing people when they're not 100%, if you will.
And you have to know that, though, right?
You do.
Okay. And we found that out I actually found it out a few weeks ago, but for the first time, everybody else in the courtroom found that out the other day.
Yes.
Okay. So you agree with me that, so you can go ahead and look at them. I'm sorry, I don't mean to be distracted.
No, you're fine. You're fine.
You couldn't tell he'd been on a bender
somebody
for
that
5
has been up
days.
for 5 days using methamphetamine, that could affect an interview.
I'm not an expert on drugs and everything, but yes, I would think it would.
Okay. And have you done any studies about individuals who have addiction not just to methamphetamine, to controlled substance in interviews?
I have not.
Okay. And are you aware that both Miss Snellen, were you told that prior to? Was a
I gathered that from the interrogation.
okay, and also Charlie Girdley.
Yes.
Okay, and isn't it true that those individuals, are you aware how many times they've been interviewed?
I only know 2 for both of them.
Okay, they had been interviewed more than that. Okay, and that was Miss Snellen was clean when she was interviewed there. Okay, back when she was first interviewed, I think she was interviewed twice. If I remember correctly. She was an active user. Okay.
Okay.
And she had testified that one of her suppliers was Joseph Lawson.
Okay.
Okay. And you also heard testimony that you listened to the entire interview. The interview was 4 hours.
Yes.
We listened to about approximately 2 minutes of clips that were selected out of there by the defense counsel.
It seemed like longer than 2 minutes, but we listened to some clips that was not the whole interview.
Okay. Yes. Well, Miss Snell, I don't think.
Snell. Okay. Yeah. Okay.
Yeah. Mr. Gurley, there was probably 5 minutes of clips.
Again,
I'm just guessing.
Yeah,
More 5 minutes.
I don't know, but it's fair to say that those aren't all the clips, and this is just subset.
We've been
Because
at this
the
for like an
interview,
hour
I
and
think
a
the
half.
combined interviews of Mr. Gurley was probably somewhere around 6 or 7 hours. Is that fair to say?
Correct.
Okay, and we listened to probably 5 to 6 minutes of clips.
Okay.
All right. So you've published a lot, right?
I have.
And I think Brian went through a lot of it. It was from memory for complex events.
Yes.
Phenomenology of memory, is that correct?
Yes.
Eyewitness memory?
Yes.
False memories?
Yes.
Applied cognitive psychology?
Yes.
Psychology in the law?
Yes.
Collaborative recall?
Yes.
And mnemonic devices?
Yes.
Correct. Okay. You don't list false confessions as an area of interest in research, do you?
I'm not sure if I do.
Okay. Well, it wasn't in your resume.
Okay.
All right. And you don't list coerced confessions as one of your areas of research either?
No, I don't.
Okay. One area you have published extensively about is the unreliability of informant testimony. Okay, and I've done a lot of dope cases. All right, so these are usually people looking to get out of jail, right? 90% of the times, or not go to jail. Correct.
Correct. Or some other benefit that they want in jail.
And it's a you scratch my back, I scratch your back kind of relationship.
Yes.
Correct. All right. And many of these witnesses are willing to lie to get the benefits.
Yes.
Is that correct? Now, I agree with that. Now, Heather Snelling's not giving any benefits for testifying here in court, was she?
None that I know of.
Okay. And after her, what the jury didn't hear was that she had interviewed previously, correct? And come in and told the story. I don't remember what it was, but it was really not that significant. Would you agree?
I didn't listen to her first interview.
Oh, you didn't?
I only listened to the Kentucky State Police interviews.
Okay. Her second interview, then.
Yes.
Let's put it that way. The first of the Kentucky State Police interviews.
Bye, Angie.
There's really nothing of great significance.
I only watched the one that we.
Oh, you didn't watch the first one?
No, that's the only one I've seen.
All right. And did you know that after the first interview, they told her, if you think of anything else, just give us a call and you can come back in.
I was aware of that.
Okay. And she called them, didn't she?
I believe so.
Yes. And she advised them that she had more information to give. Is that correct?
I think so, yes.
Okay. And the one thing is that Joseph Lawson had contacted her for an alibi. Is that correct?
That's right. From the interview, that's what I gathered.
Okay.
Yes.
And she provided that information. Is that correct?
Correct.
Okay. And at one point in the interview, she was told that that's all you got, you can leave, right?
Which interview were you talking
The second state police interview.
Is that the one I watched?
Yes, sir.
Yes, she was.
She was. They told her, listen, if that's all you got, you can go. Correct?
I think that they said it. I'm not sure they said it.
Well, I'm not using exact words.
Right.
Probably not in that tone either.
All right. And she didn't leave. Is that correct?
Correct.
All right. And she told the police about that conversation between Joey and Steve, correct?
She did.
Okay. Now, are you aware that, and she said that they moved the body on the Houck farm. Is that?
Yes, I believe that. I remember that.
And are you aware that Crystal Rogers was on the Houck farm on the evening of July 3rd, 2015?
I believe I am aware of that, yes.
Okay.
And did she also express during that interview with Kentucky State Police is that she was scared of Joseph Lawson and scared of Stephen Lawson?
You may.
So we object to the question. I think Mr. Butler had been okay with certain questions and things like that, but obviously we object because we didn't open any sort of door to this. And obviously threats of a witness and portraying him in some sort of violent manner was never evidence that we put into play here. And it's actually part of the reason why we asked for a severance from this case, is so that we could maintain control of what doors are opened. And obviously we didn't have any control over that. So we would ask, I think at least an admonition, at this point, to not use that evidence against Joey Lawson.
It's my understanding the defense counsel is operating up a joint defense agreement. One for one, one for all.
I mean, leave it this way. If you are joined as two defendants, whether or not, there is interests that are aligned when it comes to, defenses, that's still a product of being joined, right? So still there's lack of control over what door was opened. And so that's the prejudice that was caused by the joinder of the two defendants, is that we don't have control over, doors being opened. And that door was obviously not opened by Joey Lawson. Okay. And that is evidence of threats and violence about Joey, supposedly coming from Joey Lawson.
She just said she was scared of him. I didn't say they threatened.
If you would just rephrase your question, if she is scared of, could that affect her in her willingness to tell information? So what I'm saying, if she's afraid.
I heard Karen Reed was trying to get the sidebars from her trials public. Oh,
So
I hope she does, because I need to know what was said up there.
If someone is scared, could that affect their ability to give information?
Yes.
Okay. Now, we've talked about this, but she's given a number of statements, correct?
Yes.
And she was talking to them. She wasn't under oath there, correct?
No.
Okay. And she come in here on court on, I think it was last Friday. Did you get a chance to watch her testimony?
I did not.
Okay. Well, she was sitting right where you were. She come up, raised her hand in front of the jury, and swore to tell the truth, the whole truth, and nothing but the truth. Okay. And she was asked a lot about what you all went through. Matter of fact, I think everything you reviewed, she was asked about. Okay. And she agreed with it. And she said they were mean to her. And she really didn't appreciate it. Okay. And she also testified about the alibi, that Joseph had asked her to give her an alibi. And she also testified that she heard a conversation between.
I mean, she also says she heard Joey and Steve say they killed her.
About any alibi testimony.
But no charges for that.
I was surprised it didn't come in, but it never came in. So, so I would ask for an additional.
Joey asked her where he was that day.
No,
It's different than saying.
it was never called an alibi.
I'll rephrase it.
I do not care for prosecutor Shane Young. He's very sneaky.
She testified that she was contacted by Joseph Lawson, and he asked her if he was with her that day.
You don't have to do all that when you have a solid case, bro.
So, but that come up in your review of that. Is that correct?
I believe it did. Yes.
Okay. And your testimony today is that Heather's statements to the police were the result of police coercion. Is that correct?
Yes.
Okay.
And in particular, you listed a number of tactics that were used, like you listed accusation, deception, threats, promises of leniency. I don't know all the rest of them, but there's a bunch of them.
Yes, you do, Shane.
Now, when you didn't watch it, but I'm going to represent to you, okay, and somebody can speak up if they disagree. I was in court, I was standing right here, and she was right there, okay? Yes. And there was no state police or anything in here, correct? And I didn't threaten her. I didn't promise her anything. All I asked her to do, and I said, I don't care what the truth is. Whatever it is fine with me. And I said, just simply tell the ladies and gentlemen of the jury, whatever it is, the truth. And she repeated that statement, that the Houcks, or that the Steve and Joseph Lawson moved the body on the Houck farm. Now, is there anything coercive about that?
No.
That's the same thing, Shane.
No. Okay.
It's like apples and oranges. One is a tiny room that you're trapped in, and this is in public.
About that she was coerced by the police. Okay? Right. And you would agree with me that anytime police officers question a suspect, it's stressful.
Yes.
All right. And many people just get stressed out if there's a police car behind them with lights on and they don't even know they're getting pulled over, right?
Agreed.
And the stress level goes up if they are pulled over.
Yes.
And I get stressed out and have trouble. You never can find the insurance card. And you just get nervous and you haven't even done anything wrong.
Right.
Maybe speeding, but that ain't, you're not going to jail or speeding.
As a memory expert, I tell you, just put it in the same place so you know where it is always.
Yeah.
Like your
Well,
keys
now it's
in
on
the
my
morning.
phone. I don't even worry about it.
There you go.
Yeah, because it's on the
And the police haven't even asked them a single question normally before they're sweating. Right.
I agree.
So police interviews can be stressful. And an interview is not accusatory, is that correct?
It should not be accusatory.
Yes. And
shouldn't be.
Sometimes when the police have been provided information that someone may have been involved in a case, okay? Such as the police were provided information that Heather Snellman was with Steve Lawson at a bar.
Yeah.
It is a mess. Just like Dave said, this whole trial is just a mess.
I don't think he can go and throw in facts like that which are not true, because then we're going to end up, this is completely collateral. She wasn't at the bar with Steve Lawson.
I understand she wasn't, but the police thought they had been given information. That's why they were asking her those questions. And I think if you're going to play clips of them asking her, they're being mean to her, whatever, the jury has to know what the police understood to be the facts at that time. They have to have context.
The problem with that is it's not true, and we don't know if it's allowed.
It isn't true.
We don't know if they believed it at the time or they were lying to her at the time. None of that. That's the problem with throwing those kind of facts out. Well, what the purpose what the purpose of his testimony was, these are coercive tactics. When Shane asked the question, could witnesses be afraid? Could that be that's a fair question. That's a fair commentary. But what he's doing is now testifying to what people are saying in court. The first thing, I let that one go. Now he's going to throw out this statement that's just not true. None of it's true. There's no evidence of that in the case. In fact, I think Shane just admitted he knows it's not true. That's completely irrelevant.
Man, those tactics sound kind of familiar.
Because that's what the police believed at the time. I agree it's not true. They figured it out it wasn't true, but that's why they were pushing her, is they believed she was involved, and that puts that in context why that interview was that way.
Your Honor, I think it's irrelevant. There's nothing further.
I don't allow you to ask questions about if they had information. I don't want to get this information. I've got enough information in this case. I don't want to throw out false information. If you would say, if they've been told something that they're relying upon, it turns out that was false, could that, if you see what I'm saying?
I don't have an objection to that. I don't have an objection.
What about if I tell them that they were told that she possibly was involved in the case?
That's exactly the same thing.
I'm not throwing anybody else in there.
You would have to do this, Shane, if you had a strong case.
Put in there, and it was found out to be untrue. I don't need.
I'll tell that. I don't mind. I'm just trying to put it in context.
Yeah, I just don't want facts coming out that aren't true.
Does it point about piggybacking off of that is this witness doesn't know that truth or whether or not he can
He
evaluate.
can't test. That's I agree with that. That's exactly
He's
right.
coming in saying, I think he has a right to say if they were given information that was untrue, could that explain why they were pushing and things of that nature? I don't
So
want to
we
get into the specifics of the untrue
Right.
information.
Okay. Yeah, fair enough.
Shane's entire case hinges on.
So, Doctor, is it fair to
interviews.
say that you did not know what the detectives knew at that time?
Yes, that's fair.
And if they were given information that they were relying on that was untrue and that they believed to be true at the time they were questioning Ms. Snellen on, that could change the tone of the interview, correct?
I imagine, yes.
Okay, it could turn more into an interrogation. Is that correct?
If they thought that Ms. Snellen was lying to them?
Yes, sir.
Yes.
Yes, sir. And in fact, she had called them and told them she had more information. Was that correct?
She did.
And then when she was offered a chance to leave,
I just took a big drink of coffee.
that was it. She didn't leave.
I mean, I disagree that she was really allowed to leave. What I viewed, the officer stepped in front of her.
No, I'm talking. This is earlier on in the interview.
She was offered chances to leave.
Yes, sir. She could have gotten left, right? And she chose to stay.
I feel like she felt it was it didn't seem like she really felt like she had the opportunity to leave.
Well, were you in her head?
That was not.
Okay, and she was told she could leave. Is that correct?
She was told that, yes.
Okay.
Sneaky little snake he is.
Now, in interviews, they generally don't threaten the witness, do they?
No.
They generally don't lie to a witness. Is that correct?
Sometimes they lie to the witnesses.
In an interview?
In an interview? Oh, no, in interrogation, you're right. Correct, no.
All the time.
And they don't share evidence, do they, in the interview?
They usually don't, no.
Yeah. They actually want to hear, really, the witness has the floor, and they just want to hear what the witness has to say. In an interrogation, that changes, correct?
That does.
But please take this lead on that, right?
Correct.
Okay. The witness and the police officer can actually become a suspect during an interview, correct?
No, sorry,
The police in an interview, sometimes the witness can become a suspect.
Yes,
Is that
of course,
correct?
yes.
And it'll turn more into an interrogation. Is that correct?
Yes.
And sometimes witnesses will lie. Is that correct?
That is correct.
Okay. And during an interrogation, the police nominate the interview. Is that correct?
Yes.
And that's a generally accepted practice.
It is.
Okay. They may interrupt the suspect.
Yes.
They can cut off the suspects.
They can.
They can accuse the suspect of lying.
They can.
They can confront the witness with evidence that proves they are lying. Is that correct?
They can, yes.
Because you want to let them know, hey, listen, I know, right?
They can do those things,
You
yes.
can do those things, yes.
But other things.
They can
happen.
even lie about the evidence against the suspect. The courts have said that's an acceptable practice, correct?
That's right.
They're not pleasant. The majority of interrogations are not pleasant.
They're not.
And they can be intense.
Yes.
People cry.
Yes.
And people yell.
Yes.
And all interrogations involve some coercion, correct?
Not all, no.
Some level.
Some I've seen don't involve any.
Don't need it.
And the United States Supreme Court has defined them as inherently compelling. Is that correct?
I believe so.
Okay. The suspect is isolated from loved ones.
He is.
They're usually placed in a small room, correct?
Yep.
There's no clock.
Nope.
There's very little furniture.
Very little.
And this is accepted across the country and pretty typical. Is that correct?
Yes.
Okay.
Doesn't make it great.
The door to the interrogation room is
That
closed.
happens.
Correct.
Doesn't mean it's okay.
Many suspects don't come out and tell the truth right away. Is that correct?
Until they confess, yes.
All right. Especially if they have lied in previous interviews.
I mean, I don't know if that's the criteria they use.
Okay. Well, I read an article. Anyway, that's okay.
I read something on the internet.
But you haven't reviewed those, right?
Reviewed what?
Her previous interviews.
No, I've not.
Okay. It can be like pulling teeth sometimes to get somebody to tell the truth. Is that correct?
I'm sure it can be.
Just him
Okay.
saying, well, I read
Have
an
you ever
article
done
and
an
then stopped it,
interrogation? I have not. Have you ever
implies to
done
the
a police
jury
interview?
that he knows
Have
something.
you ever dealt with individuals who were active
makes this
users of
wrong.
methamphetamine?
No, sir.
Do you have any background in dealing with those individuals?
I do not.
in your opinion, are all of the persuasive tactics that police use are coercive?
No.
This is the part you've been waiting for, by the way.
Many of the tactics that you deem coercive result in statements that are allowed into court. Is that correct?
They do, yes.
Right.
Doesn't make it right.
So your definition of coercion doesn't always square with what the law allows. Is that
That's
correct?
correct.
Sometimes it's legal.
Some of the stuff they do, like you just said, lying, all that stuff is legal.
Okay.
But that's fruit of the poisonous tree.
Let's assume some of the tactics that instilling were coercive, okay? Coerced statements can still be true. Is that correct?
Certainly.
Right. And in fact, many coerced statements are true.
I would imagine.
They can be true in the laboratory experiments that you discussed earlier, right?
Yes.
Okay. And they can be true in real world interrogations.
Correct.
All right. So Mr. Gurley, let's talk about Mr. Gurley a little bit, okay? He's in a different boat, right?
Right.
Mr. Gurley's going to jail.
Right.
And he come in here and testified the other day. And Mr. Gurley, he's dealt with the police quite a bit, okay? And would you agree with me that someone who has dealt with the police or been interviewed by the police on not ongoing basis, but multiple times, probably has a little more experience in it than?
Yeah, he's probably much more savvy than your regular run-of-the-mill person who doesn't have that experience.
And probably someone who is adept or used to certain techniques the police use.
I would imagine.
Right. And sometimes police might have to go into the toolbox and get another tool out to use on somebody like Charlie.
They may.
Okay. Now, did you watch all three of Mr. Gurley's interviews?
No, I watched the one that day and then the two that were showed here.
Okay. So the same thing. Mr. Gurley came into court on Monday. Okay. He was by himself. He stood here in front of the court and was sworn in. Okay. And he advised, he was testifying under oath. And he advised that Steve Lawson had confronted him and said that Brooks wanted to get rid of his old lady. He also said that Joey Lawson said he would bury the fucking car and that he had pulled the hair and teeth and hogs to get rid of the rest. And that was, and I told him, I don't care what the truth is, okay? We're here right now. You're not in interrogation. I have no charges on you. You're not on probation. Just please tell the ladies and gentlemen of the jury the truth, and that's what he told him. Now, is that a coercive environment?
No.
Do you have any really reason to believe that statement was coerced?
No.
Okay. Now, Charlie was never charged with a crime in this case either, was he?
Not that I'm aware.
He wasn't. Tell me about when people are interviewed over and over and over and nothing, and are they scared to change their story the next time they come in if they've withheld information?
I don't know if they're scared.
Well, I'm not scared. Are they more hesitant?
I couldn't say how individual people think about things, but what happens over repeated interviews is that people get the impression, at least in laboratory studies, that their information they're giving is not correct and they need to come up with different information. Otherwise, why would they be continuing the interview?
Okay. What about people who have been threatened to be arrested and they never get arrested?
What's the question?
They give an interview or interrogation and they're threatened to be arrested, but they're never arrested. And they're interviewed again. And they are threatened to be arrested or told that they would be charged and they're never charged.
Would that get them to change their story more?
No, what I'm asking is, it's kind of like positive reinforcement.
Okay.
You know, like the whole kind of,
Yeah.
Pavlov or whatever.
Right.
If you keep saying the same old thing, and they say something will happen to you, but it never happens to you, you're more apt to say the same thing next time.
If they're being reinforced for it, yes.
Yes. And I think you said you got $10,000 too?
I did.
Okay. Did you, one of the most important areas I think is, did you have a chance to review Brooks Houck statement?
I did not know.
Did you have a chance to review Rebecca Greer's statement?
No, I did not.
Stacy Cramners?
No.
Barbara Coulters?
No.
Mary Beth Mattingly?
No.
Richie Riggs?
No.
Rebecca Greer?
No.
I'm sorry, I actually haven't already. Ashley Nally?
No.
Holly Fenwick?
No.
Amber Bowman?
No.
Danny Singleton?
No.
And your testimony is that affectionately touching people, you shouldn't do that, right?
I don't think you should, no.
It's not hurting anybody.
No.
You agree? I mean, they're not physically beating it out of them or something. They're just touching them. Is that fair to say?
Right.
Okay.
There's Kathy. Good morning to you, babe. Afternoon on my end, but morning to you.
Now, do people normally just come in and confess right away in a murder case?
I've seen it, but it's pretty unusual.
It is pretty unusual. And at one point, Luckett says to Charlie, he goes, "We will protect you." And do you know what he's referring to?
I assume that he was referring to from the Lawsons and Mr. Houck.
Okay. Now, Charlie that night, and I agree with you. Once I learned that Charlie had been up for 5 days, that whole interview is a little iffy. Okay,
A little.
But he actually corrected himself at one time, right?
Right.
He just didn't give him. They were happy. He said that Brooks Houck gave him the keys, right?
Of course they were.
Pretty good. But Charlie actually went back and corrected them. He goes, "No, it was not Brooks Houck. It was Steve and Joey." Is that correct?
Right.
Okay. So he was somewhat in control of his faculties and was able to correct himself. Is that correct?
He corrected himself.
And what I mean by that is he had fed them information that obviously they were satisfied with because they didn't go back to it, correct?
Correct.
And then, but he had the faculties about him to correct it and say it was Steve and Joseph Lawson that had the keys, correct?
Yes.
Well, if I remember right, on the stand, he didn't say anything about Steve. I thought that got moved to the 12.
Now, if this information that Charlie gave had been corroborated by others, would it be deemed more trustworthy?
As long as there was no, so the problem with is not whether the information is correct, it's how Charlie comes by it. So Charlie may not be more trustworthy, but the information may be.
That's what I'm talking about. The information may be more trustworthy. Okay. And I think, and maybe I'm wrong. Did you say that the interrogation shouldn't last more than 2 to 4 hours? Is that what you said?
2 to 4 hours
Okay.
is what the read technique says.
Give me 1 second, Doctor. I'm probably done with you. And I'll let you, Mr. Coleman and then Mr. Butler, if they have any more questions. Hang on 1 second. Hi, and thank you very much for answering my questions.
You don't have any questions? Any redirect?
Very briefly. Just want to go back to just a couple points that
Certainly.
Mr. Young made. He was asking questions about these techniques. The read, is it for witness interviews or interrogations?
It's for both. So they say that you should use the same interrogation technique for non-cooperative witnesses.
So the types of things that we talked about, and I'm not going to.
Oh my God, that coffee was so hot.
The types of things we talked about, promises of leniency,
Oh.
threats of consequences, so on and so forth. Are those the things that have led in the literature to false statements?
Yes.
Now, to be clear, none of the stuff that we're talking about that we saw on the tape that the police did was illegal.
No.
I mean, it's not illegal. They
It is not.
They're allowed to lie to people, correct? They're allowed to yell, right?
Right.
They're allowed to be rude, right?
Yes.
And they're allowed to simply act ugly, right?
Yes.
And
I burnt my whole tongue.
explain why those things are problematic to get the truth, not whether they're legal or illegal.
So the reason they're problematic to get the truth is because if you look at the social influence and the social persuasion literature, those things lead people to give statements that are in line with what they're being asked to do rather than statements that are factually accurate.
And can it, if you hypothetically give a false statement or coarse statement, through a coercive process, is it surprising if someone says, hey, just tell the truth, that they would repeat that statement?
So we talked about post-event information. So you can consider the interview post-event information. They may come to believe this information after telling it, or they may believe that the contingency for them still exists.
When you say contingency, meaning something bad could happen to me if I don't repeat what I said.
Correct.
Anything else? Just one more. So based on that, what's that called? Post what?
Event information.
Okay. Well, they obviously didn't believe the information. They didn't get in their memory when they were telling the statements before, which you hadn't watched, right? They're different from these. They obviously didn't believe that when they went in there and told that, correct?
I don't know.
Okay.
Because I don't know the
And
statement.
you're really just guessing, right? You don't know.
So I don't make. I don't know what the truth is. I make no assertions about the reliability. I just
That's
know
up to them, right?
Right.
Yes, sir. Thank you.
Any questions from any jurors? Question? See counsel at the bench.
Oh, interesting, Kathy. I got to get caught up on all that. I don't even really know what all it's about. Oh, jury questions.
According to your expertise, if an individual goes into questioning voluntarily and is there for over 4 hours, could their judgment and memory possibly be wrong or clouded?
That's fine. Yeah,
That's fine.
That's good.
Your question is, let everybody get to their seat there. According to your expertise, if an individual goes into questioning voluntarily and is there for over 4 hours, could their judgment and memory possibly be wrong or clouded?
Yes.
Any questions based upon the jurors' questions?
No.
May this witness be finally excused?
Yes.
You're finally excused. You may go. Tell you what, why don't we take a break before we
I thought he was a
start the
great
next
witness.
Ladies and gentlemen, the jury, the same admonitions are
By
in
the way,
place. We'll
found
start
him
back in
interesting
15 minutes. You may go.
compared to some of the other ones. Obviously, we know this doesn't affect the jury very much, but again, it goes towards my points anyway of why I personally, if I was on the jury, I would have to throw out all of this evidence because a lot of it's tainted. And especially, like I said earlier, eyewitness testimony is already a very not good for evidence. And then you add the eyewitness who's on drugs, that makes it even less reliable. And then you have interviews like these with a lot of coercion, a lot of threats of people who do know the consequences. They've all been in jail. They don't want that life. You know, they don't want to do that. So for me, like, that just really throws out anything they have to say, whether they're telling the truth or not. Like, I'm not saying that Heather was lying, but
At this time, let the record reflect all
They
15
tainted
jurors have returned to the courtroom. Everyone may be seated. Counsel waived the call.
that's why it's not illegal, but it doesn't look good in court.
Your Honor, we would call Denver Butler.
Denver Butler.
Oh, yeah. Very interesting.
Thank you.
I wonder if he did Steve's trial. He was LNTP retired. So, yes. You know, it's a hard word to spell. Sergeant. Who else can't spell it right the first time?
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you, sir. If you'll have a seat right over there. Please sit as close to the microphone as you can, and please answer all questions asked of you. Mr. Butler, proceed when you're ready.
Thank you, Your Honor. Can you introduce yourself, ladies and gentlemen, jury, please?
My name is Denver Butler.
And before we get started, we're not related.
We're not.
All right. You tell ladies and gentlemen, the jury, you were a police officer, correct?
I was.
And can you tell them a little bit about your police experience?
So I started my law enforcement career in 1991 with the Jefferson County Sheriff's Department in Louisville.
Should not have been
And
the
then
right word.
in September of 91, I was hired on with the Jefferson County Police Department. In 2002, I was promoted to sergeant.
That's interesting.
And then 2003, the Louisville Police Department and the Jefferson County Police Department merged and created the Louisville Metro Police Department. And I finished out my career there, retiring in 2012.
And while you were with let's kind of break down your experience with the police department. What did you work homicides?
I retired from homicide, yes.
Okay, tell us a little bit about your experience investigating homicides.
Experience with homicide started when I was a sergeant in our criminal intelligence unit, where I would work as a support role for the homicide unit if they needed someone surveilled, interviewed, just whatever support roles we could handle. And then in 2008, I was transferred to the homicide unit as a sergeant and worked one of the shifts, which picked up homicide cases. And then about a year and a half later, we created a cold case unit, and I was a sergeant over that unit until my retirement in 2012.
Okay, you mentioned the term cold case. What, ladies and gentlemen, that may not know what that is. What's that?
So a cold case is a case that has gone unsolved for a period of time, and either the assigned detective had been transferred out. We found that those were not getting the attention they needed, so we created a cold case unit where we could track those cases and
Be like Kathy and hit the like
follow up
button.
on leads and things of that nature, and also apply the newer technologies to the older cases involving DNA, fingerprint analysis, hair trace evidence, all of those new technologies that came about.
And sir, when you left in 2012 as retirement from LMPD, can you tell us what the next part of your career was?
I then served 2 terms as a Kentucky State Representative from the South Louisville District 38, and did that for 2 terms. And then while serving as a state representative, I served on the Justice Committee and other criminal justice related committees.
Okay, what's the Justice Committee, since you mentioned that?
I was the chairman of the subcommittee that handled the budget for the Justice Cabinet, which was about a $6 billion budget.
At some point, were you appointed to lead a state agency?
I was. After serving as a state representative, I worked for 2 years as for a governor in the Justice and Public Safety Cabinet, and served as commissioner of the juvenile justice system, and also worked as a senior advisor on criminal justice issues to the administration.
Look, I wore my sparkly silver
And
shirt for you today, inspired by your
You
dollhouse.
left that. Can you tell ladies and gentlemen of the jury what you do now?
So in 2020, I founded a nonprofit called Clemency Investigations, which focuses on reviewing convictions with a claim of innocence.
Oh, wow.
And had been doing that ever since. And I also have a consulting business that after I retired had opened, that I did expert reports for civil right violation claims in federal court and some state courts for a period of time.
And so, with your work with investigating, some of these words are legal terms, investigating clemency, explain who hires you, how does that work, specific to that nonprofit?
So right now I'm working with 2 prosecutors' offices, one in Michigan and one in Tennessee. Kind of the government's response to wrongful convictions has been to create units within the prosecutor's offices called conviction integrity units. And it's usually a prosecutor assigned to review those claims to see if there was any merit to it. I partner with them at no charge to them, no cost to them, and conduct the reviews and give my findings back to them.
Have you been responsible for freeing innocent people?
I played a role, yes, sir.
Now, in this case, we hired you to look at police searches and laboratory reports to help summarize those for the jury, correct?
That's correct.
Okay. And how much have you been paid so far to do that?
I've been paid $2,200, and the total bill will be around $7,000.
Oh, he's a chosen.
So, have you been recognized as an expert by courts regarding crime scene analysis?
For police investigations and police practices, yes, sir.
Or I would consider him an expert in crime scene analysis, police practice.
You may.
Brian asked him if he was an expert, recognized an expert in crime scene analysis. He said, I'm recognized as an expert in police practices and investigations. I don't.
I'm fine if you want to say he's an expert in police practices and investigations.
Raise your question in.
Yeah. Okay. Yes, sir.
Yeah, take care of it.
Thank you.
Okay, sir. Okay.
Let me rephrase my question. Have you been recognized as an expert in police investigations?
I have.
I would consider him as an expert.
No, the ejection shall so stipulate at this time.
Now, I'm going to show you a few just summary exhibits before we get started with some of the searches and things like that. That's all right.
I wonder what this guy's going to say. I really don't know. Maybe point out all the things that investigators didn't do right away.
Oh, sir.
Maybe.
I'm showing you what I've marked as Defendant's Exhibit 24,
A bad investigation.
Defendant's Exhibit 25, and Defendant's Exhibit number 26. Let's start with Exhibit number 24. This is a celluloid extraction, if you can put that up.
Right.
If
I'm
you
always
can't, let me know. I'll just have to read it. Detective, I've shown you what was an extraction report from celluloid. Because we've heard a lot about this, I'm not going to ask you too many questions. Celluloid is an activity law enforcement does to download a phone, correct?
Correct.
Now, this one is from Tammy Lawson's phone, and it begins July the 4th, 2015, and that's it. 1:13 a.m. If you could let ladies and gentlemen of the jury know what she's texting to Steve Lawson at the time.
Are you talking about the text number 2?
Yes, sir.
On text number 2, if that bitch brings the drama here. It's going to be a girl thing.
And then she texts again, and that's at
I love when I
1:35.
make them read.
Stevie, come in here.
And then at 2:21 a.m.
You need to call and see if it is stolen. Stevie, I swear you do.
I don't think 5 has any relevance, but 6, please.
I'm texting that bitch.
And 7. And that's at 10:33 a.m. the next morning.
You need your tools.
And at 12:20 p.m. the next day.
You know the B with stars, cop happy.
And then 12:25 on July 4th.
She can't call the police on you over a phone call.
Your Honor, I move to the admission of that exhibit.
Any objection 24? Show it's introduced at this time.
And now if we could turn to exhibit number 25, please. Phone records. And Detective, what I'm showing you in the second page of that, it has subscriber information. Can you tell, ladies and gentlemen, the jury, who the subscriber is on the second page of that document?
Right.
The
Our
subscriber
proctors.
is Tammy Lawson.
Okay. And sir, these are AT&T records obtained by law enforcement. If you would look at line, the first highlighted one, which would be at July the 4th, and that would be at 2:31 a.m. because it's UTC time. We've learned about that. Can you tell us what number Tammy Lawson was calling at 2:31 a.m. on July the 4th?
That is a number to Capital One.
Can you verify that?
Yes.
Now, at 2:36, Tammy Lawson makes another call, and that one lasts for 1:24 seconds. Can you tell us who that call is to?
It's either the Nelson County Sheriff's Office or the Bardstown Police Department, and the bottom one is the other.
Okay, so the next one is the Bardstown Police Department, one is the Nelson County Sheriff's Office, vice versa.
That's correct.
All right, I move the admission of exhibit number 20.
The objection 25. Show that's introduced at this time.
Now, if you would, you have exhibit number 26 in front of you, please.
I do.
Now, this is a text messages between Ms. Rogers and Brooks Houck on June the 26th of 2015. So this would have been approximately a week before her disappearance. 13:22, Ms. Rogers is texting Brooks. 13:22 would be 1:22 in the afternoon, correct?
Correct.
And if you can read for us what Ms. Rogers texts Brooks.
July 6th, 2:45 is Eli's eye appointment.
And Brooks's response.
Sounds good. Thank you.
And the next one.
Is it here at Physician to Children or Dr. Franklin in Louisville?
And then she texts back, it's in Louisville, correct?
Correct.
Now, let's generally talk about, you can take that down, Sandy, with that. Let's generally talk about response to a crime scene, what law enforcement does. We'll get more specific about this case, but just you have a homicide, you have a robbery. What does law enforcement do to process that crime scene?
Law enforcement responds to a call, typically from a citizen, and once they get there, they assess the situation and then call whatever resources are available to appropriately investigate the incident.
Okay, so in this case, we've heard evidence that on July 5th of 2015, Ms. Rogers' car was found on the Bluegrass Parkway. You're familiar with that?
Correct.
Police responded. So what do they do? What do they do with the car? How do they process the car?
I believe they moved the car on a wrecker to a secure facility where they control the environment, and then called in the specialists, the crime scene technicians, to process the vehicle based off the information they had at the time. And it would be a collaborative effort where the investigators would share with the crime scene techs what they believe happened, and then the crime scene tech would offer whatever technologies and resources they have to best collect whatever evidence they're looking for.
Okay, in this particular case, he's talking about processing the car. Let me try to get to the right. There's so much here. It indicates that and if you need to refer to notes, please let us know. Did law enforcement swab the car?
Correct.
Okay, let's start with that. What does a swab mean?
So you would be trying to collect any trace evidence, skin cell DNA, touch DNA, blood evidence, saliva evidence, and you would swab the areas that person or persons would have to access the vehicle or operate the vehicle or manipulate anything within the vehicle. So you're looking at interior, exterior door handles, rear view mirrors, front and back, steering wheel, gear shifts, anything that a person would touch or transfer bodily fluids.
In this case, were those things done?
They were.
And if you would please put up slide 1. Actually, not slide 1. I'm coming back to that. Slide 3, please. And as you testified, and for demonstrative purposes for the jury, one of the things you would expect law enforcement to do would be to swab the steering wheel, correct?
Correct.
And why would you swab the steering wheel?
Hopefully to identify anyone that operated the vehicle within a short period of time that may be involved in the car being abandoned on the roadway.
Do you have to bleed or on the steering wheel to leave DNA?
You do not.
And what types of things leave DNA?
There's skin cell DNA, coughing, sneezing would probably leave trace amounts of DNA. There's hair evidence that could be collected.
And sweat can leave DNA as well, correct?
And sweat can leave DNA.
Now, likewise, would you anticipate that they would swab the front driver's exterior door?
Correct.
And did they do that?
They did.
And so we don't take so long. That's obviously you have to open the door to get in it, right?
Right.
Did they swab the front driver's interior door?
They did.
Did they swab the gear shifts?
Yes, they did.
Did they do trace slips from the driver's seat?
They did.
And trace slips from the driver's side floorboard?
Correct.
Now, they also did trace slips from other parts of the car and swabbed from other parts of the car, correct?
Yes.
Okay. Go to the next slide. Did they find, based on your review of the evidence that was collected, was any of Joey Lawson's fingerprints found in the car?
Not that I could find, no.
Were any hairs of Joey Lawson's found in the car?
There were not.
Was there any DNA of Joey Lawson found in this car?
Not that I could determine, no.
Was there any DNA found on the exterior door?
No, sir.
And on the gear shift?
That's correct. No DNA.
And what about Steve Lawson? Same?
The same, yes.
So no DNA of Steve Lawson in the car, correct?
That's correct.
Let's go to slide 5. There was one hair on the driver's seat that could have been tested for DNA that did not appear to be similar to Crystal Rogers' hair, correct?
That is correct.
And one in the driver's side floorboard, is that correct?
Correct.
Were those tested?
They were not.
Okay. Should they have tested those?
Yes, they should have been.
Okay. And explain what that means and what CODIS is and the genetic genealogy for us.
So depending on the style of the hair and what's on the hair, they would test it trying to pull a DNA profile from the hairs. And if they collected a DNA profile, they could test it not only against the folks that are mentioned in the case, but they could put it through CODIS if a profile was created, and also the genealogy databases, which would open it up to about 76 million more people. And if that DNA matched, they would get a lead back saying, you have a match and here's where you need to go, either through CODIS or the genealogy.
I mean, we do have a hairs, a thumbprint, and a palm print.
Go to slide 7, please.
And we don't know who they belong to.
Was Brooks Houck's home searched?
It was.
And that was pursuant to a consent, correct?
I believe it was, yes.
And can you tell ladies and gentlemen what a consent is versus a search warrant?
So law enforcement, if the homeowner is there, which I believe Brooks was the homeowner, they can ask. The homeowner doesn't have to allow law enforcement in. In this case, he cooperated with law enforcement, gave them consent to search, and I don't believe law enforcement found anything out of place.
Was there ever any evidence collected that you've been able to find from reviewing this?
I don't believe so, no.
Were there photographs taken?
Not that I'm aware of.
Was there an inventory of what they looked at, to the best of your knowledge? And there's, in fairness, there's 2.5 terabytes worth of information here. So are you aware of that?
Yeah, I am.
Now, likewise, if you go to slide 8, please. Mr. Houck's Brooks's truck was searched on July the 6th of 2015. Is that accurate?
It is.
And based on your review, was anything of evidentiary value found in that truck?
No, I think on the July 6th search of the truck, Mr. Houck cooperated with law enforcement and gave them consent. It wasn't pursuant to a search warrant.
Now, was Nick Houck's, this would be slide 6, please. Was Nick Houck's police car, was it searched?
It was.
Now, again, we've talked about, was the car swabbed looking for DNA?
Correct.
And were tape lips used?
They were.
Was there any evidence, trace evidence associated with Crystal Rogers, DNA, anything along those lines in Nick Houck's police cruiser, or any of the items in Nick Houck's police cruiser?
There was no evidence collected that showed anything of a crime.
If we could go to slide number 9, please. Now, there've been, let's go through this, there've been a multitude of searches of the Houck property. Is that fair to say?
That is correct.
Okay. And the first search pursuant to reviewing the documentation was on July the 6th, correct?
Correct.
And again, try to go through this, get the important points out with not taking too much of everyone's time. It was searched again on July the 7th, correct?
I believe both of those were with cooperation of the home. They consented.
And then here's part of this slide's a photograph of law enforcement looking through a burn pile, correct?
Correct.
And it was searched again on July the 10th. Is that accurate?
I believe so, yes.
And again, there was no trace evidence found associated with Crystal Rogers, correct?
That is correct.
And did they find any personal effects anywhere on the farm at either of those 3 occasions?
Nothing.
Now, on May the 14th of 2016, can you go to slide 10, please? Did law enforcement do a search of a white Buick that was previously owned by Anna Whiteside?
Yes, sir.
And again, did they take the car and did they take it into a secure location to process the car?
They did.
Did they do swabs and cuttings from the car?
Yes, sir.
And then, if I can, before we get back to White Buick, I'm just going to show you 2 forensic laboratory reports related to the processing of Nick Houck's police car.
Yes, sir.
Those indicate that the law enforcement processed them and found no blood evidence. Correct?
Correct.
Can I move the admission of 26, 27, and 28, please?
So 26 through 28 is introduced at this time.
Okay, Detective, I'm going to show you what I've marked as defendants exhibit 29, 30, 31, and 32. 29 is a cutting from the carpet of Anna Whiteside's Buick.
I don't know if it's a cutting, but it's
the trunk carpet, correct?
Yes, carpet in the trunk.
And 30 is What's the picture of?
30 is, I assume that is, they're spraying, there appears to be stains in 29 in the carpet, in the trunk, and then a technique or technology that law enforcement has access to is called luminol, where you can spray a substance on stains and it will, once a light source is added to it, it becomes a color of a smurf, for lack of a better term, glows blue. And then from there, you would do further tests and analysis to figure out what it's reacting to. And that would be 29 and 30.
And that's what you're talking about, where they're spraying.
That's right.
And presumptively, they thought it could be blood that they looked at, correct?
Yes.
And they tested that like they should have, correct?
Correct.
And the finding was no human blood, correct?
That is correct.
So they did, is it fair to say that they did what you would expect law enforcement to do with regard to DNA swabbing this car?
Yes.
Okay. And was any human blood found in the car?
Was not.
Okay. Was any blood or tissue Crystal Rogers found in that white Buick?
No.
I didn't move for the addition of those exhibits, please.
Point out the 32 injection. I'll show those are introduced at this time.
Now, they also did hair collection from the car, is that correct?
Correct.
You could put the slide 12 up, please. And multiple hairs found in the car, is that correct?
I believe so, yes, sir.
And that included animal hairs, pubic hairs, mixed race hairs. Is that accurate?
Yes.
Now, one hair was deemed, and I'll try to quote from the report, similar in color and limited microscopic characteristics. You're familiar with that?
I am.
So as an investigator, at that point in time, what do you do if you have a dissimilar, similar and limited characteristics or similar? If you're an investigator, what do you do if something is limited, similar and limited characteristics?
You would talk with the crime scene techs and especially the lab and see what you could do to further identify that hair. And I think in this case they did do that.
And what did they do?
It's a process. I've talked on the phone dozens of times about it. I don't know how it's done, but it typically consumes the hair.
You send it for DNA, is what you're.
Yes.
Okay. And in this case, this was sent off for DNA as you would expect.
It was.
And were they able to get a profile?
They were not.
And it's not their fault that the hair was consumed, correct?
Yeah, I mean, that's part of the process.
Now, do you make identifications based on the initial screening process of hair analysis?
No.
And in fact, it's led to multiple wrongful convictions, has it not?
It has.
So what you do, and that's what they did, they tried to do the right thing. They tried to send it for DNA tests, correct?
That is correct.
So the result, was there any DNA of Crystal Rogers in Anna Whiteside's, or formerly Anna Whiteside's white Buick?
There was not.
Did they exercise a search warrant on 3505 Cox's Whiteside Road, Cox's Creek?
Yes, sir, they did.
And they were looking for what, sir?
Cleaning products, vacuum cleaning rags, and they recovered, I believe, a vacuum cleaner.
Did anything come of that? Was there any evidence found there?
Not that I could determine, no.
Did they also exercise a search warrant on Pulliam Drive, which was Anna Whiteside's home?
Yes, sir, they did.
And did they likewise, can you tell us what they were looking for and if they found anything of evidentiary value?
They did not find anything.
Now, moving forward, it's a search of Fabian Ballard's property, which would be slide 18, as well as, I believe, the Houck Farm at 345 Pascal Ballard Road. Are you familiar with that?
I am.
And this would have been in August of 2016. Is that correct, sir?
August 30th, 2016.
Now I'm going to show you, if I can, 2 exhibits, Detective.
Sorry, I'm back, guys. My little llama clog is on vacation in the Outer Banks. So I haven't got to talk to him since he's been going because he's been busy, but he just called me. He's adorable. Have I missed anything of importance? Oh, look, we're all coming back at the same time in chat, apparently. I don't think we'll still do the missing kid milk cartons, if that's what you're referring to. Welcome back, Leading Gray. Welcome back. Ooh. He sent some pictures of his time there, and apparently in one of the Carolinas, I don't know which one has the Outer Banks, to be honest, but they have Cheez-Its that are Wendy's Baconator
That's
flavored.
just the FBI lab report that you testified to about the attempt to get DNA. And then the next exhibit before you, if you can tell, ladies and gentlemen, jury, what that is. That's not on the slide.
Yeah, Exhibit 34 is a search entry and exit log for the August 30th, 2016 search of Fabian Ballard's farm. Where law enforcement, when they enter an area to be searched, they're usually given tasks in any search warrant, and then if they leave the premises, then they sign out.
Something
It
that
is a control mechanism for we know who's in and who's out.
Yes, sir. Is from looking at that based on your training in law enforcement, is that a significant search?
It is. It's very manpower intensive.
Every day you're thirsty, Kelly. Let's be honest.
And during that search, they found a front loader at Fabian Ballard's property. Are you familiar with that, sir?
I am.
And did they get a presumptive? And I'll show it to you if you need me to.
Oh, that's funny. I'm glad you think so.
Detective Mr. Butler, I'm going to show you what I've marked as defendant's exhibit number 35. I'm also going to show you some evidence tech notes related to that. Likewise, in this particular search, when they were searching buildings and equipment, did law enforcement use luminol or other blood testing?
That's true.
They did. I just want to back up on Exhibit 34 is also It's 8:30 and 8:31, 16. There's
It's a 2 day
2 day search, and I think there's 13 pages of sign in and out of personnel being utilized. I'm sorry, now on 35?
35, along with that search, they did luminol testing in multiple places, but they got a presumptive positive from a front loader.
It appears they did, correct.
And can you explain what a presumptive positive for blood would be?
So just like the carpet, they would spray and it would glow, turn a different color, and that would be an indicator that there may be blood presence.
So it could be. So did they do what they were supposed to?
They did.
Okay, and they sent those examples off, correct?
Correct.
And was there any blood found?
There was not.
During this
2
day search with, I don't know how many officers, but a lot, correct?
13 pages. So you figure 6 to 7 pages a day. I'd say there's 20 to a page. Quite a few.
And was there any, and is also involved Rosemary Houck's farm too, which is a 345 Pascal ballot as well as Fabian's. Is that right?
Correct.
Okay.
If you can go to the next slide for us. And did they find any trace evidence associated with Crystal Rogers on either of those farms in this 2 day search?
Nothing.
Did they find any personal effects of Miss Rogers?
They did not.
And I think that's a summary of the various officers that you've already talked about. Is that accurate, sir?
That's correct.
And 21. There's also digging on that farm as well. Is that correct during that time?
There was.
Now I'm going to go back a little bit here to November 16th through 20th of 2015. Be familiar with bodies of water in and around that area, Melody Lake, Sportsman's Lake, Vegas
question.
Reservoir.
I am.
I've never heard one have
And
as
did
many
law
searches as
enforcement
this one.
search those?
They did.
Okay, and how did they go about doing that?
I believe the Louisville dive team worked with them, and the FBI also brought in a specialty dive team from Miami.
I can't wait to see it.
And used newest technology, including sonar and videos, to search the bodies of water.
Now, you talked a little bit at the beginning of our discussion about the difference between consent and search warrants. And for brevity person, the consent, you ask the person, hey, can I do this? And they say yes or no, correct?
Correct.
With a search warrant, can you explain to ladies and gentlemen, Drew, what the process as a law enforcement officer is for getting a search warrant?
Yeah, so the reason you would do a search warrant with a consent, typically the person who consents has to be there throughout the search, and they can withdraw the consent at any point. To protect law enforcement, sometimes it's safer to get a search warrant. And
Always
the
make them
process
ask.
for that,
Always make them
in
get a warrant,
layman's
guys.
terms, is you take everything you've learned in the investigation through evidence collection, through statements, through experience being involved in cases, and you apply an affidavit, which is, for a lack of a better term, a story. You want to tell the judge the story of why you believe that you have probable cause to believe that evidence of a crime would be present and be found.
So you take that and you go to a judge and you say, this is what I think. I think I'm going to find evidence there, and then the court has to make a determination, correct? Is that a fair summary of it?
That's correct, and it's under oath.
And so if the court says, okay, I believe you, I think you'll find evidence there, then you're allowed to search for whatever you've asked to search for at wherever location you're asking to search. Is
That is correct.
Okay.
Always ask for a warrant for everything. Search, DNA.
move us along. That's not leading on anything important. It's just
You
foundation
had the
stuff.
question went correct. I mean,
Let's don't lead the witness.
I'll try not to lead.
I
Before we
suspect
go, I mean, on this foundation stuff, you want to not lead?
No,
I mean, it's going to
no.
take twice as long.
no, I mean,
I'll
I'm
try
okay
not to.
with the
I'll try not
foundations.
to
Don't-
do a
don't-
leading
I
on a
don't-
zinger.
Well, I don't need your little comments at the end. Okay.
I'll try not to do it.
Says Shane of all people. Okay, sir. Oh, I don't need your little comments at the end, Mister. I put in comments all of the
So,
time.
Detective, now
that are
let's
bogus.
just turn to
That guy.
August 6th to 9th of 2020. And that would be slide number 24, please.
Move my face.
Okay, was there a search of the Houck family farm on 345 Pascal Valley Road between August 6th and August 9th of 2020?
There was.
Now, can you give us a brief overview of what law enforcement was looking for as far as physical evidence at that time?
They were looking for any DNA, trace evidence, effects of Crystal Rogers, anything of evidentiary nature to show that a crime had occurred.
Now, at this point, I want to talk to you a little bit about blood evidence, if we can. We are 5 years and a month from Miss Rogers' disappearance when the search is conducted. Explain why law enforcement might be looking for blood or DNA evidence 5 years after a disappearance.
Because my experience with homicide investigations is, in this case, from what I know and from what I've read, it's a reasonable belief that it would still be there. That DNA could still be present. Any trace evidence could still be present. And so DNA is difficult to cover up, and it has been found on older tools that were, hundreds of thousands of years old. They were able to collect DNA from stuff. In homicide cases, many times, like a handle of a knife or a gun, they can go back in and find years later DNA in those handles and the crevices or things like that.
If blood is spilled on a carpet, in your experience, is it easy to clean?
It's easy to clean the carpet, but it's extremely difficult to remove all the DNA.
What about in your experience with flooring? If there's crevices, cracks, wood, is it easy to remove blood
everywhere.
or DNA evidence?
On the surface, I would say someone would think it is, but even
tore up half the county.
concrete, it would absorb, blood would absorb into that.
Found.
Blood is going to find, or any bodily fluid would drain into the crevices, and that would be a place that you would look to collect DNA, and it would still be there years later.
And what about outside? If you think a crime occurred outside, can you still look for evidence, or would you still look for evidence?
Sure. Yeah.
Explain that for us.
In many of the cases, homicide cases I've worked, outdoor crime scenes tend to give a lot of DNA evidence. It's there. It may soak into the ground. It's evidence just like the inside. On outside crime scenes, it's very difficult to cover it up or to clean it up.
So the FBI, in your opinion, they didn't do anything wrong by going and asking to search again 5 years later?
I think they were doing their due diligence, and they brought in the best of the best and the brightest of the brightest from the country to search for any evidence to lead to a crime.
Let's talk a little bit about what they used on this August 6th through 9th Did they use canines?
They did.
Did they use drones?
They did.
Okay, explain why law enforcement might use a drone in their searching.
To search for clothing, to search for bodies, to search for undisturbed earth mounds. It could be a variety of different issues. To take pictures to grid. So you have people searching gridded off sections so you're not stepping on one another and you're making sure that it's a complete search.
Did they use ground penetrating radar?
They did.
Can you explain how that's used?
With my experience with it, I had one case where I had contacted the FBI about using it, and they are able to go in above the ground and see if there's any anomalies below the surface. And if so, then they would make a determination on how to deal with it.
You said in the one case, is in your experience in law enforcement, do you typically have access to drones and ground penetrating radar as a Louisville Metro police officer?
They'll probably.
We would reach out to the FBI for assistance. And in the case that I had, I reached out and it was determined it wouldn't have been viable to check because there had been a parking lot and a condominium built on top of the property.
How many agents, the best you could tell, participated in this 4-day search?
Over 100 agents.
Did they use luminol? And I'm not even going to attempt to say it. If you can tell me what that other word is from the search warrants and what the purpose of those are.
The luminol and I don't even know it either. Starts with a PH, and it's a long word. And that would be to spray to see if there's presence of blood.
Flylene?
And they collected fabric, correct?
They did.
Did they find blood on that?
That's a stupid word.
Did they search ponds on the property?
They did.
And did they locate anything of evidentiary value?
They did not.
Did they do, let me ask you first, what's a grid search?
A grid search would be, if we were going to search the area here in front of me, you would just draw straight lines both ways, and then you would number the grids, and you would assign personnel to search that grid. And then if something is found in that grid, they would be able to document from that grid to make sure we know where the evidence is coming from, who collected it, and creating that report.
Did they also search surrounding properties?
Yes.
The Evelyn property, a Lawrence Ballard, and a Wallace Livers?
They did.
Did they search ponds?
They did.
Did they search the farm with canines, or the farms with canines?
Yes, sir, they did.
Was any evidence, any trace evidence found?
There was not.
Any personal effects of Miss Rogers found?
Nothing.
Now, if we could turn to August 30th of 2021. Did the FBI search
here's your
properties near 108 North
Here's your
Howard
clothes,
They did.
Michael.
And so when they do that, you can tell, ladies and gentlemen of the jury, what they did and what they found.
So they dug up a driveway and a porch that was being developed, I believe, near the time of Crystal's disappearance. And they located some women's underwear that was under the driveway, which contained hairs, and located clothing underneath the sidewalk near the front porch. And the FBI, at the time they collected it, they thought that it possibly belonged to Miss Rogers.
And did they test that?
They did.
And can you tell, ladies and gentlemen of the jury, what those findings were?
Crystal Rogers' DNA was not found on these items.
Did they find anything that they could associate with Crystal Rogers?
They did not.
Now turning to October of 2022. Did law enforcement primarily the FBI, once again searched the Houck farm and areas around the Houck farm.
They did.
And how long was that search?
I believe it was 3 days.
And approximately how many agents did they have searching on this time?
Over 20 agents.
And again, can you tell us what they were looking for?
They would be looking for evidence of a crime to include DNA, blood, fingerprints, Crystal's remains, Crystal's personal effects.
And there was a gazebo in the back of behind Miss Rosemary Houck's house. Did they look under that, in that?
They did.
Did they dig near the house in the garage?
They did.
Did they search again the skid house that was on the property?
They did.
And that had been searched previously, had it not?
It had.
They collected multiple items. Is that accurate, sir?
It is.
And that included, if you can tell us what all they collected.
Seized blue bucket lids, seized razor blades, shop lights, a roll of plastic sheeting, swabbed blades, hand saws, also seized saw and blades, seized wood from the bottom trim near the garage door and main door, seized weather strip from the garage door, swabbed the skid house, 20 different swabs at different locations, and seized tire repair tool and tire insertion tools.
And did they find any evidence of a crime scene on this particular occasion, sir?
They did not.
Did they find any trace evidence associated with Crystal Rogers?
Nothing.
Did they find any personal effects of Miss Rogers?
They did not.
And for brevity, so trace evidence, blood, fingerprints, skin cells, physical things you can touch, right?
Correct.
Now, did law enforcement search Thompson Ridge?
Let me interrupt you here, Mr. Todd.
Yes, sir.
Might be a good time for a lunch break.
Yes, sir.
So, ladies and gentlemen, the jury, we're going to go ahead and give you a lunch break. Same admonition.
So, yes, they had a lot of searches, a lot of agencies with really good resources, and found Zippy Zap in 10 years. They don't know where she is, how she died, where she's buried, what was used to kill her. Nothing.
Everything has to be based solely upon the
Nada.
evidence presented in this courtroom. I'll let you go with the bailiff. Be back at 1:20 for the entire court.
Personally, I don't think her body's probably in Nelson County. And for those of you that are new, I do think Brooks Houck had something to do with it, but they haven't proved really anything to me so far in this case, which is beyond disappointing. I'm very angry about this, actually. I think this is the last part of
At this
the
time, the
day.
record reflect all 15 jurors have returned to the courtroom. Everyone may be seated. Counsel waived the call.
Yes.
Please proceed, Mr. Butler. Sir, you're still under oath, okay?
There we go.
Yes, sir. Under oath.
Yeah, approach, Your Honor.
You may.
Text, I'm going to show you before we get back to
It
some
is.
searches. I'm going to show you what I've marked as Defendant's Exhibit 36 and Defendant's Exhibit 37. And these appear to be representative pictures from the search on the North Howard property.
They do.
I move the admission of all exhibits we take so far that have not been admitted.
Mhm. And then we have to think of all the other cases I talked about in Bardstown. Officer Jason
Any
Ellis,
objection? 33
no,
through
I'm sorry.
36.
Tommy Ballard,
33 through 36.
the Netherlands.
Okay, I'll show their
Like-
introduced at this time.
I'm going to show you now what I've marked as Defendant's Exhibit number 38. Does that appear to be the laboratory report from the FBI finding no DNA for Crystal Rogers related to the North Howard search?
It does.
I'm going to come back with 39, so I'm going to show you.
If you haven't, I'd go watch my deep dive series then
about,
too.
Just to get them admitted. I'm
All
showing
of
you
it.
defendant's exhibit number 40. Does that appear to be the Brooks Houck's consent to search his residence at 113 Glenview?
On July 6th, correct.
Move the admission of defendant's exhibit 40. 39 I filled out, Your Honor. We're going to talk about that one.
Objection to 40. I'll show it's introduced.
Detective, or I'm going to show you what I've marked as defendant's exhibit 41. This appears to be evidence tracker report from the Nelson County Sheriff's Department related to the swabs and other investigative techniques that they used on Ms. Rogers' car.
That's correct.
Move to the admission of defendant's exhibit 40.
Any objection to 40? Okay, I'll show it's introduced.
And I'm showing you what I've marked as defendant's exhibit 42. Does that appear to be showing that they executed a search warrant to obtain Google data related to Mr. Houck on July 28th, 2015?
It does.
Move to the admission of 42.
It is. And thank you, Lady and Gray.
I'll show it's introduced at this time.
Okay, we left off, I think we had talked about a search at the Houck farm in 2022.
Correct.
And if I could approach and if we could go to slide number 30, please. First document I'm showing you, I'm not going to move to admission, but this is just the search warrant for that. If you could just tell us what law enforcement was looking for, Detective, at Thompson Ridge.
You want to know what they're looking for?
Yes, sir.
They're looking for the following described personal property. One, human remains and or partial human remains, biological and serological evidence, including but not limited to blood and or blood stains, DNA, bones, and bone fragments and teeth. Two, any and all personal effects that may belong to Crystal Rogers, including but not limited to clothing, jewelry, photographs, and notes.
Hey, Jenny, I'm going to stop there. Mr. Young has more questions about that. That's what I really want to focus on. I'm showing you what I've marked as defendant's exhibit number 39. Can you tell, ladies and gentlemen of the jury, what that is, please?
This appears to be the sign-in log for the search warrant at Thompson Hill Road for law enforcement and folks that assisted law enforcement.
And does that also include plan for different sites that they were going to look at on that area?
It does, with a diagram of a mobile home as well.
Now, one of the things that you had mentioned in this is that they might be looking for clothing, jewelry, photographs, notes, anything that might be associated with Crystal Rogers.
That is correct.
Explain, if you can, we're at this point, we're 8.5 years past her disappearance. Allegation is that something happened at night by the Commonwealth. Why might you be looking for things outside 8 years later?
Trying to locate her body.
What about personal effects? Why might that be something that they would try to find? And is it easy? What I'm asking is it difficult to clean up crime scenes at night?
Yes.
Why?
It just adds another layer, especially being outside and dark. It just makes it extremely difficult.
Difficult to clean up
clean
a violent crime scene.
And so they're not doing anything wrong by saying, hey, we want to go look for personal effects in an outdoor area, correct?
There are many non-violent.
So they searched the Thompson Ridge on December 20th of 2023. Is that accurate?
Correct.
And that involved Kentucky State police officers and FBI agents. Is that?
That is correct.
Okay. And did they find anything of evidentiary value at Thompson Ridge?
Nothing.
Now, we've heard a little bit about Thompson Ridge. If you could tell, ladies and gentlemen of the jury, approximately where it is in relation to downtown Bardstown.
It's about, I want to say 13 miles north of Bardstown, of the downtown limits, maybe 11 miles. outlandy roads, country roads.
And if we can orient, you've been out there before, correct?
I have.
You actually drove me.
I did.
113 Glenview Drive, which has been identified in the trial as the residence of Brooks Houck. Is this fairly accurately represented on a map where the Thompson Hill area is?
It does.
So to orient the jury, that's actually as you're going north toward Fulton County, getting closer to Jefferson County, correct?
Correct.
And then do we also drive from there to the mile marker 14 on the Bluegrass Parkway?
We did.
Okay. And can you tell just total driving distance what that is to go from the Thompson Hill Road to the Bluegrass Parkway at mile marker 14?
From Thompson Hill Road is 22 miles to the Bluegrass Parkway.
And if you went from Glenview Drive to Thompson Hill Road back through Bardstown, the quickest way to mile marker 14, can you tell the ladies and gentlemen jury how many miles that is?
It would be 37.3 miles.
And finally, Detective, there was a search conducted at Cox's Creek, which is a property associated with the Houck family. And can you tell ladies and gentlemen jury when that was? And that's slide 32.
September of 2024.
And can you tell ladies and gentlemen jury what they were looking for, where they searched?
The FBI agents searched a well under the porch in the basement, and they utilized construction companies, brought in heavy equipment to help with the search.
And likewise, they swabbed things like we've talked about for DNA and looked for hairs and fibers as you've described, correct?
Correct.
And did they find any evidence of a crime scene, trace evidence, or any personal effects of Ms. Rogers?
Nothing.
I just have a couple minutes, Judge.
I think that would make me a terrible PI because I would just get like stuck on one case. Remember. I am very thorough as well. And I do think the investigation, like all these searches, we're not like done in vain.
I'm sorry. I would move the admission of the summary of our PowerPoint examination. I would mark that as full phrase.
We would object to that. Yes, there is an objection to the bench.
Judge, they put the evidence in. I mean, they put the evidence in they needed. They talked about the labs. It's all on record. But the PowerPoint, it's just deceptive. I mean, because there was no DNA of Crystal Rogers found. Well, there was no DNA found. I mean, I just think it's prejudicial. I think the evidence is in record. The detectives testified to it, and we would just object to the PowerPoint being admitted in evidence. It's demonstrative. I don't mind them using it. I didn't object to them using it in front of the jury, but being admitted to evidence, I would.
Fair. It is demonstrative.
Admitted under 1006 in summary. This is voluminous information.
And Judge, it's prejudicial. I didn't object to it on the record because I was letting them go through it. But going back to the jury, I do object to it.
I'll sustain the objection. I don't think it should be introduced, but I will certainly during your closing, you can present all that on
yes,
yes.
That's not a surprising ruling. You remember those Yannetti binders? Beautiful. Or I'm sorry, Alessi's binders, not Yannetti. Well, probably him too, but Alessi's were best binders ever.
Good afternoon, Dan.
Good afternoon, sir.
Just for ladies and gentlemen, jury, it's a little awkward for me. Me and Denny know each other. But I got a question. So, why did you do all that driving?
Why did I do the driving from the house to Thompson Hill to 44?
Right.
Or to mile marker 14? At the request of Mr. Butler.
You reviewed the file, right?
No,
You hadn't reviewed the file?
I have not.
Okay. Well, there's no allegation that Brooks Houck drove to mile marker 14, and there's no allegation that Brooks Houck drove to Thompson Hill Road. So do you understand why? Do you know why you did it?
I do not.
Okay, me neither. Let's talk a little bit about Ivan Kano. You know who that is?
Ivan Kano?
Kano, sorry,
Yes.
I'm not pronouncing.
Yes.
Okay, and that's the little boy that was murdered up in Louisville, correct?
Correct.
Exactly. Objection. Why are you bringing up another case again? Shane, I bet Kelly does have an AJ Brander.
It's a kid that was murdered up in Louisville, but they never found the body. And they searched. The entire police department searched that.
I'm sorry. I withdraw the objection. I don't know what, I mean, what are you going to ask when I come back up?
I'm just going to ask you if they never found the body. And if there's all these officers searching the landfill.
Oh, that's fair.
This is
That's
not-
fair. I'm sorry. I thought you were going at some case he did.
No.
I don't think it's relevant,
You can go ahead.
but I'm
You can go
also
ahead. Did you already answer the question?
What's that?
Did you answer the question already?
Was I aware of it?
Yes.
Yes.
Okay, and supposedly he was in a landfill, correct?
It was before my time in homicide.
Okay, do you know about it?
We were part
Let
of
me
the
see.
suspect end of the case.
Okay, and he was, but they never found his body, correct?
I believe they did.
Okay, no, I don't think they did. There's a landfill, they searched, they never could find it.
I believe they found him in the back of a garbage truck.
No.
What was the
I don't
case?
think so.
Case is
Okay,
something out of Kentucky.
let's talk about, you worked on Ann Gottlieb though, didn't you?
I did.
Okay, was there any DNA on Ann Gottlieb?
There was not.
Okay, did she just disappear?
She disappeared in June 1st, 1983 from Bashford Manor Shopping Mall, and the only thing that was left behind was a bicycle.
Bicycle, right.
Yeah, and I don't know if they swabbed it or not because DNA technology wasn't around then.
There really wasn't a crime scene, correct? You don't even know if she was on the bicycle or anything, right?
I do not.
Okay, and she never was found?
Correct.
Okay. It's a sad case. I mean, I'm not making light of anything. I'm just saying it's a sad case. So the labs you talked about, and I know they had those slides up there that said crystal DNA not found. There just wasn't any DNA found, correct?
That's, sorry, Shane.
You're up.
Mm-hmm.
DNA found in some of these things. It just wasn't hers. There was DNA.
All right, let me clarify the question.
Okay, yeah, that's not.
You see how Shane tries to get things in
So,
there? Like, oh, you're right.
As it relates to the
I forgot.
the white Buick, okay,
Yes,
there
sir.
was no DNA found. It just, crystal wasn't excluded in that, right? The hair and the hair that was tested in the white Buick,
Correct.
the one that, I don't remember the right terminology, but the one that
Was consumed.
yes,
Yes.
there was no DNA found, right?
There was not a profile.
Right. Well, there's no they were not able to exclude or include, correct? Because they did not develop a profile.
Correct.
Okay. And the same thing happened at North Howard. Is that correct?
I'm not aware of any DNA being found.
Okay. Well, there was then we also talked about the where they dug the house up, right? You know, the ground up by the house. There was a pair of underwear found.
Sure.
Okay, and the same thing happened with that, correct?
This is in
That they sent off for
They sent out
trace
the
evidence.
and it was consumed, correct?
I believe so, yes.
Okay, and so she wasn't either included or excluded with that because there was no profile developed, correct?
That's correct.
Okay. All right. Now, you talked about the two hairs in the car. Is that correct? The two hairs in Crystal's car?
Yes.
Okay. And there's been testimony here and you may not be aware of it because you probably haven't been here, but where Joseph Lawson admitted to Rebecca Greer that him and Steve Lawson had moved the car.
I was not aware of that.
Okay. And are you aware of the hair links?
I'm not.
Okay. And so the hair links were, I think, 7 1/4 inches and 11 7/8 inches. Longer than your typical male hair. Would you agree with that?
It doesn't exclude them.
No, but it's longer than your typical male hair. Is that correct?
If we're counting me and you, yes.
Well, I mean, look out there.
Sure.
I mean, longer than your typical male hair, correct?
I don't know what typical male hair would be.
All right. And it was color treated.
I believe it was treated, yes.
Okay. And if you looked at that, just being a person looking at it, you would think that's probably a female hair, correct?
I mean,
Not necessarily, no.
guys dye their hair all the time.
Now, what all did you review in this?
The labs, the things we talked about on the,
Well, I think I got it in your disclosure. Hang on a second.
Okay.
It says portions of a discovery provided by the Commonwealth with an emphasis on alleged crime scenes, lab reports, and interviews.
correct.
Okay. Did you watch Brooks Houck's interview?
This is the second time.
Portions of it, yes.
Okay. Did you find that to be a course of interview?
Excuse me?
Did you find that to be a course of interview?
A coercive interview?
Course, yes.
With Detective Snow?
Yeah.
No,
Okay. And so, and he was free to leave, right?
I don't know that.
Okay.
But
Well,
he was not under arrest and he left.
yes. And you've been a detective before, correct?
I have,
You were a detective for a year in homicide, correct?
4 years.
Okay. Well, you were a cold case for 3, right? And then 1 in actual homicide. Is that fair to say?
But cold case isn't homicide.
Well, I got you. But
Yeah.
there's a difference.
Yeah, but I still work homicides, fresh homicides.
Okay. And you would ask people to write statements. Is that correct?
Depends.
Did you sometimes ask them?
To write statements, I don't believe
Okay.
I did, no.
Okay. Well, let me ask you this. If you were to ask somebody to write down everything they'd done that day, everywhere they went, what would you expect?
Are we doing a hypothetical or?
Yes, sir.
It's a dangerous way to go.
Well, I appreciate the commentary.
There's a lot of context to it.
Okay. If I asked you to write down everything you did a day, that on, let's say, Thursday today, okay, could you list everything you've done today and everywhere you've been?
Today, yes.
Yes. If I were to ask you tomorrow about today, would you be able to do it?
That I can't tell you 100%.
Okay.
We're
Would you
getting
get the
older.
majority of it right?
I would think I would.
Would you be able to tell that you went to Bowling Green?
Yes.
Okay.
You're so sneaky.
Now, are you aware of, you watched that interview with Snow and you said that you didn't think it was coercive, correct?
Portions of it.
Yeah,
I
we
didn't
watched
watch the whole
portions
thing.
of that.
I've watched the full tapes of other ones that I thought were coercive.
Oh.
So you went and watched with Houck, you did?
With what?
With the defendant
No
Houck
way.
interview? You
Did I
said-
watch portions of it? Yes.
You said you watched other interviews of defendant Houck you thought were.
No.
Okay.
No. I
Other-
think there was only the one.
He never
that I was
said
provided.
There was 3.
He said
Was
other
it?
videos
Um,
that he thought were coercive.
Now, you would agree with me that not all crime scenes are going to have bodily fluids.
Mm-hmm.
That's a fair statement.
Okay. And matter of fact, if you,
And I'm going through my head what we talked about. Ann Gottlieb did not have.
You know, I think there's a
bodily
word
fluid.
for that.
and if somebody, you know, and you're
Called
a police
integrity?
officer, right? You've been doing that for,
Since 1991.
yes. And you retired in 12, is that right?
Correct.
Okay. So you were a police officer for 21 years. Is that fair?
Correct.
Okay. And if you had to plan out a murder, okay?
If I had to what?
Plan a murder.
Okay.
What? Objection. Yes. Yes. Exactly. This is what.
I think I made my point.
Oh, you think you made your point?
I don't even know where to begin. Sorry about that. I don't know where. Planning murders? I mean, come on.
Yeah.
Objected. It's speculative. If you were going to commit a murder,
Yeah. I was going to ask him how he planned it out so there wouldn't be evidence found.
Object, that's
I got my point
speculative.
across. I know. I got you.
Sustain the objection.
I got you.
See, it's just all like, oh, special prosecutor, everybody. I wonder how much the state paid him.
Okay. Are there ways to kill somebody and not leave bodily fluids?
Yes.
I'm sure it's possible, but highly unlikely.
But it's possible, right?
Anything's possible.
If you move them quick enough.
All right. Were you aware that Nick Houck was off the grid for 24 hours?
I had heard that, but I did not look into it or.
Okay. And were you aware that Brooks Houck was at his farm all day long when she failed to put on a written statement on July 3rd?
I knew the fact that, that there was a discrepancy there.
Okay. Now, you went over some text between Tammy and Steve Lawson, is that correct?
Correct.
Okay. And they were like at 2 a.m, right?
That's on July 3rd, I believe.
Yes, sir. That was on 3rd, and then it went into the 4th even, I think. No, it was on 2 a.m. on the 4th.
Is this when they're looking for the Chrysler 300?
They're talking about the Chrysler.
Yes.
Yes. And it went through that weekend, right?
That, I don't know.
They only let you look at one text?
That's what I saw here today.
That's all you looked at?
I looked at the text between Brooks and Crystal Rogers.
Okay. But did you review the rest of Tammy and Steve Lawson?
I did not.
Okay. Would it surprise you that they texted about the Chrysler all weekend?
No.
No, it wouldn't.
Okay.
It's what people usually do when they think somebody took their car.
Now, you also talked about the searches at the Houck farm. Is that correct?
Correct.
And that there was no traces of Crystal Rogers there.
Correct.
Okay. And did you realize, according to Rhonda Houck, that she was at the farm quite a bit?
I was not aware of that.
You weren't? Okay. And so would it surprise you, even though she's at the farm quite a bit, that there wouldn't be any DNA there? Or traces of it? I think you call it trace evidence.
Can you repeat that question?
Since she was at the farm quite a bit. Okay. Quite a bit meaning.
I don't know if she was or not.
No, I'm saying there's been testimony that she was there quite a bit.
Sure.
Would it surprise you that there was no trace evidence of it?
No, what surprises me is the theory is she was murdered there. In my experience with homicides, is homicides leave trace evidence.
Okay, and where did you get the theory why she was murdered there?
From the search warrants.
Okay. And what if that's wrong?
On all of them?
Yeah.
That she wasn't murdered there?
I don't know. I don't know where she was murdered.
You keep saying it's the farm,
You
though,
just
buddy.
asked me if I was surprised her DNA wasn't there. My experience with
Not what I'm
homicide
saying
cases.
I'm saying what the question was this.
Okay.
The question was since she frequented the farm a lot,
right?
Were you surprised there was no DNA evidence or trace evidence?
No, that doesn't surprise me.
And we just talked about you could commit a murder and there not be any fluids, right?
My experience with homicides, and there's quite a few, is that there are bodily fluids, blood,
and you work
in a vast majority.
And if you had enough time to plan a murder, you could do it where there would not be any of that, correct?
I think it would be extremely difficult.
But you could do it.
I think anything would be possible, but
Yes.
it's highly unlikely.
But you could do it.
It's possible, but highly unlikely.
And how many homicides were you lead investigator on?
Lead investigator on.
I found 7, I'm sorry.
Maybe a little higher than that.
I found 7 on court net where your list is lead.
Okay.
All right. Were you aware that 6 out of the 7 were dismissed?
Are you talking about Ricky Kelly's case?
Ricky Kelly ended up getting convicted of manslaughter.
Correct.
The others were dismissed.
Of his cases?
No.
Judge, give me a approach.
Why were they dismissed, though? Is that relevant? How and why? Probably.
Kelly killed a witness, number one.
Oh.
That's why his case in federal court got dismissed. They assassinated the main witness. That's so misleading. Number two, we agreed that we could have summary witnesses. The only opinion I asked him was, should they have tested the hairs? He's cross-examined on that fairly. He has not given an opinion as to whether or not Brooks Houck is innocent or guilty. He doesn't know. Shane's asking about stuff he didn't even review. We had him review Steve and Joey Lawson. I don't even know if he looked at Gertley's stuff. Once upon a time, we were trying to decide whether we were going to use a academic or a police officer to review the interrogations. We decided to use the academic because we thought it'd be cumulative to ask. We agreed to summary type evidence here. This is a summary witness. He's only given. Go back and look.
I'm not going to argue with Brian about it. I'm good.
All right.
I'm not going to argue about it. It's fine. It's fine. Don't worry. That's because you know it's BS.
I'm going to ask you about some ways that somebody could kill somebody. Okay.
Okay.
All right. So you could suffocate somebody, correct?
Yes.
You could poison somebody, correct?
Correct.
You could use a ligature. Is that correct?
Mm-hmm.
Correct.
And you could strangulate somebody, correct?
Correct.
And I understand with strangulation on the body itself, there may be physical evidence you could look for, petechia, and other things, if the person possibly urinated on themselves or whatever. But there are ways besides shooting somebody or stabbing somebody to kill somebody, correct?
Yes.
Okay.
You could do that. Anything is possible.
Now, no.
Very misleading because he was implying it was because of shoddy police work.
And you weren't aware that Joseph Lawson admitted to being paid $50,000 and moving the car with Steve Lawson?
I was not.
Or Crystal's car?
I'm not aware of that.
I don't have any further questions.
Any questions of this witness? Any redirect?
Very
Right now, imagine we didn't hear that sidebar, right, about what it was truly about. And we would have been like, oh, why were all of his cases dismissed?
Yeah, approach, sir.
That is weird.
I'm going to ask some questions that it really matters about Ivan Kano. If you would just take a look at that and refresh your memory.
Yes.
Like that's in space. Forgot all about that.
Was the child's body found?
It was found in the back of a garbage truck.
How many homicide cases would you guesstimate you worked on over the course of your career?
Hundreds. So when I redid our case unit, there were 412 open homicides that I was responsible for. I had 2 detectives working with me that I supervised. When I was on the fresh homicide squad, I had 8 detectives that I supervised, and we worked anywhere between 60 to 70 homicides at that time of year, as well as another 300 suicide and overdoses.
Wow.
So summarized, you're above the guys you have guys working under you, and then you're supervising and working the cases with them, correct?
Correct.
So it's in the hundreds, correct?
Oh, easily.
Now, what you were asked to do in this case was not to reinvestigate it. It was to review law enforcement search warrants, law enforcement affidavits, and present 10 years of investigation to the jury. Is that a fair analysis of what you were asked to do here?
That is correct.
Now, you were asked some questions, and I'm not going to beat a dead horse here, but if someone is shot, typically, does it leave blood evidence?
Yes.
Yes.
Can you tell ladies and gentlemen, jury, what blood splatter is?
Blood spatter can happen many different ways. Once you're shot, the impact of the bullet could cause splatter. If the person is injured and moving around, there would be splatter. Or if the person is mortally wounded and falls, wherever they land, that injury could cause another splatter.
So you can have pooling of blood. It's the person falls, correct?
Correct.
And splatter can be big things you can see or small, minute particles of blood, correct?
That is correct.
Okay, if you're stabbed, what does that leave in your experience? Does that leave blood evidence?
It does.
Now, if someone is stabbing someone, in your experience as a homicide detective, not always, but do you sometimes see hand wounds where the person is with force using the knife? What causes wounds to the hand of the perpetrator?
Yeah, if there's an encounter or an altercation, sometimes the perpetrator will be injured as well.
Now, you were asked questions about ligature or hand strangulation. Recall those.
Correct.
And you were asked, about questions about smothering, correct?
Correct.
Now, when those things happen, in your experience, they're up close and personal, correct?
Correct.
Can you explain, ladies and gentlemen, jury, what defensive wounds are?
Defensive wounds would be the person that's being choked, smothered, would fight back with, could be scratch marks, it could be hair pulling, could be a number of things, but it may leave marks on the person that's doing the strangling or smothering.
That's all the questions I have.
Any recross?
No.
Any questions from any jurors? May this witness be found excused? Got a question? Is the counsel at the bench?
First question is, was December 24th the first time Thompson Hill was searched? Question number 2, was Joey or Steve's vehicles searched? Question number 3, how is blood or trace evidence affected by rain, snow, fire, and time?
Those are all good questions.
They're all fine. I don't know that he's going to know the answer to the first one, but he
can tell us.
Yeah.
Yep. That's a good question.
I have several questions here. The first question is, was December of 2024 the first time Thompson Hill was searched?
To my knowledge, yes.
Was Joey or Steve's vehicles searched?
I'm not aware of any.
How is blood or trace evidence affected by rain?
Rain could dissipate it, but I think through my experience that rain would not dissolve or get rid of the entirety of DNA or trace evidence.
How is blood or trace evidence affected by snow?
I think the same as rain. I think depending on where DNA is and the conditions it's under, DNA will, I'm trying to think of the word, fall apart, disintegrate, to where it's not useful.
How is blood or trace evidence affected by fire?
That I'm not for sure, but I know of cases where teeth and other items have been found in the ashes of a fire where a person was consumed by fire.
How is blood or trace evidence affected by time?
It depends on a bunch of variables, but I think for the most part, when you're looking for evidence of a crime, DNA is the most powerful, and I think in a murder, you would expect, a reasonable person would expect to find it.
Any redirect based upon the
I'm
juror's
very
questions?
excited about his
Yep.
special coming.
Any recross based upon the juror's questions?
You worked 600 cases.
600?
Isn't that what you said? Hundreds. You know, I think in your resume, I think it said 600. You've been involved in 600.
Well, there's 400 code cases that I reviewed, and we put through a process with the CSU folks on applying new technologies. On homicide cases, I would say I worked or supervised right at 100.
Okay.
And then on top of that, you have the suicides and.
I'm not worried about suicides.
Yeah.
Just the homicide.
Well, we still investigate the
I got
suicides
you, it's
because some
homicides.
people.
I got you.
Yeah.
How many of those do you have DNA on?
How many do we have DNA on? We try to get DNA on all
I
of
know,
them.
but did you get DNA?
Well, I don't have that number.
It's pretty low, isn't it?
I'm trying to think. When I was still there in 2012, the last year I was working was mainly the code cases, but every one of the fresh cases, the DNA was involved. There was always
No, I understand that.
some levels of
Did
DNA.
you-
Now, how much did they have?
I've been doing this 27 years and had 3 cases with DNA.
The only 3.
Sustain the objection. Anything else to this witness? No.
Dang, you guys believe that?
Any other questions from jurors? Got a question? Okay.
That's going to be the foreman right there.
Yeah, he's pretty into it.
Thank you. In your words, stating that DNA disintegrates over time and with all elements involved, then couldn't it be possible that there'd be no trace evidence is the question.
That's fine. Yeah.
I think that's okay.
Yeah, that's right.
The juror's question reads as follows. In your words, stating that DNA disintegrates over time and with all the elements involved, then couldn't it be possible there'd be no trace evidence?
Yeah, we're almost done.
It could be possible, but at the search warrant they did, the last one in 2022, there were areas that were in crevices within the skid building that would not have been in the elements where it would have decomposed the DNA. DNA would have, a reasonable investigator would have believed that DNA would have been there. That's what they were looking for in the search warrant.
Any redirect based upon that question, Mr. Beck?
No, sir.
Any recross based upon that question? Anything else from the jurors? May this witness be found excused? You're found excused. You may go. Call your next witness.
Gunner, may we approach?
You may.
There are no more witnesses.
Thank you, and please be seated.
Yep. Okay. So that's for the next day. That's the next day. There were no more witnesses, and he sent the jury home. That was all that happened that day. The defense rested. So, you guys, that was the end of the defense's case. How are y'all feeling now that we've heard it all? I'm curious how a lot of you are feeling about it. See, this is another reason why I think covering trials and people watching trials is important, because again, you can read whatever you want in the news, but there's so much nuance and the way people carry themselves and say things that are remarkably different than if you just read them. You know, you all know my stance about the whole thing. But you know, you could easily just never watch this and be like, oh yeah, they solved the whole thing. He's in prison now because of it. But they didn't actually solve anything when it comes down to it. You know, remember our charges is, I forget what the exact wording of Brooks's is, but it's murder. And then the Lawsons were conspiracy to commit murder and tampering with evidence. In regards to Joey, unlike his dad, I heard literally nothing, really. Nothing that I think is credible, right? Because all this case has is eyewitnesses. And we've talked numerous about whether or not someone wants to believe these witnesses or not. You may, and that's fine. I do not. Also, seeing the prosecutor Shane trying to be as conniving as he was, you don't need to do that when you got a strong case. You don't need to do any of this. Same with the investigators. You got a strong dead to rights case. You don't need to coerce statements. You don't need to throw bizarre questions to witnesses. I do not like the way he's playing this game. I think it's dirty. Let's see. Oh, of course. No, this case is very important. We've been waiting for answers for a long time, and it's really, really disappointing. You know, I know that the family is satisfied with the end result, which will finish up tomorrow, and that's fine. But I certainly am not pleased about it. Yes, the lovely Angie did send me all of those, so I'll take a look at them later, and then maybe we'll listen to them together in a few days when we go to watch Steve's trial. Now, Steve Lawson, if you don't know, is the father of Joey Lawson, and his trial was actually before these two guys. His trial is super short. It's like 3.5, 4 days. And apparently, Shane, the prosecutor, and his lawyers get into it quite a bit, which now is not surprising. And Steve takes the stand. So, Lady and Grace says, I'm still on the fence. I want to hear the prosecutor draw it into one picture. Yeah, that's, that is true. I'm curious how they're going to put this all together, you know, there. Yeah. Well, the witnesses are terrible. Most of them, 80% of them. And that's not, I mean, that's just is how it is. I don't think they're like horrible people or whatever their lives are. I don't really care about that. Yeah, Brooks will appeal. Everybody appeals, but appeals are very hard to come by. Very hard to come by. So, Juju Bean says every attorney is conniving, though. We need attorneys, but there ain't an honest one. You're right. They do play a lot of games. But you know what I don't want? I don't want the conniving lawyer to be the one working for the government, the person that's responsible for charging people and putting them in jail, some for the rest of their lives. I don't want the government to be conniving. I want them to have facts. I want them to have proper evidence if we're going to take away somebody's life away from that. But the state, I don't think the state needs to be conniving. I'm just saying. Just saying is all. I thought it was quite inappropriate the way that he has been towards some of these witnesses. That's really uncalled for. Yeah, I mean, I totally think he did it too, you know, but I don't know. But, you know, again, we know this jury decided what they did. They're the ones who, you know, they have that on their conscience, right? So whether, I mean, that's a really big ask of any person. So I don't think that, you know, they're all going to have different opinions about things. And again, that they're the ones who had to deal with it. We don't. We got to be, you know, outside of this. So I'm definitely not going to talk shit about the jury. I just agree to disagree with them. That's all. That's all. Yeah. Well, you know, though, here's the thing. Why aren't Nick and the mom charged with conspiracy? They can say they're co-conspirators all they want. You see charges. Why doesn't Brooks have a conspiracy charge? You know, sometimes you got to ask what's missing in the trial and be like, that's not, why is that? That's weird. Amos says, this is the third special prosecutor that I have watched in a trial that gives me icky vibes. Yeah, doesn't it? I mean, it's just very coincidence that they put these special prosecutors on. Then literally just a few months later, we have all these coercive interviews of witnesses who are not reliable. And then all of a sudden they have a break in the case with no evidence to back anything up except for hearsay. It's wild to me. And that's why I do believe that this is a political case. I mean, I've seen other cases where they've had more circumstantial evidence and wouldn't go after the perpetrator. Like you can take a nobody case to trial. It's been done. I mean, gosh, we watched Adam Montgomery. That trial makes me mad. But Harmony Montgomery, if you guys don't know, she's a child. One of the reasons why I don't do kid trials, because it just makes me so upset for a very long time. But, you know, they do have some sort of evidence then to take it to trial. This one has a whole lot of nothing, really. Right. That's true. You're trying to find the Nick Houck rifle traced. The deep dive I got to find it. That should be that information. They announced the thing about the gun when Brooks got arrested in October 2023 is when Loudmouth Shane says at the arraignment, oh, this is, you know, because he likes to just throw shit out there, whether it sticks or not, is literally what we've learned from him. Like half the stuff he said, thank goodness we could hear sidebars because it was all bullshit. But anyway, it was the arraignment of Brooks in October 2023. So that's probably going to be that's going to be the really long stream. That's like the 9-hour stream where I covered everything leading up to the trial, like from the time they were arrested to the trial. It'll be in there. And I don't remember if it was, he definitely said the thing at the hearing, but I believe that I read about, that they had already confiscated that gun several times and tested it before and it didn't match. I think that was in a motion that I read, but I definitely talked about it at some point because I was like, wait, what? So they'd already done this several times. Why is this a big deal? Oh, it's because Shane makes a big deal out of freaking nothing all the time. You know? Oh, goodness. Yeah, they don't answer to the voters at all, do they? Have a great rest of the night, Dave. Remember, we'll be here tomorrow. And tomorrow is going to be a long day because it's all closing arguments for like 6 freaking hours tomorrow. Oof, boy. But then it'll finally be over, which will be nice. Michael says legally cops can lie to you and even worse, lie to the media about you. Yes, they absolutely can. But just like in instances of this, it is the fruit of the poisonous tree. If you're not, you got to be really careful about these things because it can backfire when the trial goes to court. You know, it's been done several times all around. So it just depends what jurisdiction you're in. And just think of how many things we saw in this trial that weren't permitted in Massachusetts, okay, for Karen Reed. Now, the problem with that one is the Karen Reed side, because I have seen numerous other trials where you could bring up the FBI involved. You know, you could bring up, what was the other thing that this last witness, the police guy who's basically just talking about investigation and how that works. Defense wasn't allowed to bring a guy like that to the Karen Reed trial. You know, you can see how different things can be in jurisdictions. Now, everything they've done in this trial is pretty much, I've seen it all before. It's nothing abnormal. Whereas in Karen Reed, the reason why so many people are freaking out about it is because of how not normal that is in most jurisdictions. So I think that's really, really interesting. I mean, when it comes to due process, that's it's a big problem in a lot of places. That's why I just think, again, watching trials, this transparency in the courts is important. Very, very important. Regardless of, you know, I'm not happy about how this turned out. I'm not. Oh, thank you, Jujubee. She said, nice hard work on this. Sherry Ballard, she will never let this end. I mean, sweet Sherry. That's Crystal's mom. You know, she lost her husband to this. She lost her daughter to this. I can't imagine, because she's not done yet, you know, at all. All right, you guys. Well, I'm going to get off of here because since I'm having a long day tomorrow, I got even more work I have to do today for all my other projects. But tomorrow, as I said, we're starting early tomorrow. Is tomorrow Wednesday? Yes, tomorrow is Wednesday. Oh gosh, y'all, I told you all 10 in the morning. No, we are starting at normal Llama time, 8:30 in the morning tomorrow. So just to let y'all know, 8:30 a.m. Eastern tomorrow morning, and we'll be watching closing statements, verdict, then their brief sentencing thing that they do in Kentucky, which I've never seen before, and then the verdict on that, which I do think will be very interesting to watch that. But so yeah, I will be here at 8:30 in the morning tomorrow. I can't promise I'll be this upbeat and looking good because I haven't been up that early in a while. But that is what we will be covering tomorrow. And then I don't know, I might ask you guys some options of what we do next, right? Because so next on my lineup, I have the Steve Lawson case, but I'm looking at another one. So we'll see. Anyway, you guys, I hope you have a wonderful rest of the day. And until next time, go forth and be amazing. All right, bye, guys.